Milord, item number 50, Milord.
0.
Yes, Milord.
Yes.
From last two times, final opportunity is being granted, Milord, to the respondent number 2 in this case. But no objection affidavit is being filed, Milord. And item,
What is the matter about?
Milord, is a case of 376, Milord.
50 only.
Yes, Milord.
Okay. Chandan Pathak. Okay, who's appearing for? You're appearing for respondent number 2. Who's appearing for respondent number 2?
Milord, from last two times, nobody is coming, Milord.
Otherwise, S. Rahman, U. Pandey appear.
Mr.
So,
Mr. E-
matter reach, have you informed him?
Milord, I have not informed him, but the last two times, Milord, this court is granting opportunity to the last opportunity to the respondent number 2 counsel, that is A. Misra.
Okay.
But he is not appearing before the court. And in connected petition in item number 51, Milord, he is appearing and taking adjournment.
Okay, let the matter reach. He will be coming, I think.
Milord, my request is my brother is also there. He is a respondent in person in item number 51, and he has a train on 4:30. So, Milord, my kindly both the matters may be taken, Milord.
But provided you inform the other side, otherwise they will not know. If you want to, if you want me to take up little early, then too you have to inform the other side.
Yes, Milord, I will take.
You try to inform the other side, bring him, then I'll take it up.
Yes, yes, Milord.
Okay.
Through registry, I will inform, Milord. We'll take the numbers.
Huh. Okay.
Let.
Fine.
May I please, your lordship?
Yes.
My lord, I beg to mention item number 14, 14 lordships.
Okay.
Lordships, this matter may please be taken up second week of September, lordship.
Why not today?
Lordships, after mentioning, I am leaving the honorable court.
Acha,
Lordship.
acha, acha. Okay. Yes, Mr. Sharma.
Lordship.
Mr. R. Sharma, learned counsel for the petitioner, submits that he has some personal difficulty in doing the matter today and has prayed for some time. Prayer is allowed. List this matter when?
Second week of September.
Second week of September. Okay, list this matter on 9th of September.
Lordship, I leave.
May I please, your lordship. My lord, the motion matter will be taken tomorrow, madam. Yesterday we have filed. Urgency is there, madam.
It's okay,
What?
you approach the registry because
No, but
they know how to list it before
no,
what bench.
So there is a urgency is there. Warrant will be issued day after tomorrow. That's
How
why
can
my
you say that warrant will be
no,
issued?
no,
This is
because
a bail
date is-
application.
No, the date is fixed. Until any notice is issued, then my lord, kindly my lord, taken tomorrow. madam.
This is a bail application.
No, not bail, no, criminal petition, my lord.
Acha, challenging
Criminal.
what? Challenging NBW.
Not NVW, my lord. Because the maintenance has to be paid, my lord. So otherwise, if day after tomorrow is not paid, I am ready to pay, my lord. But the notice will be issued, so I am
distress warrant.
challenging the judgment and order. my lord. Until it is challenged, so my lord, the court below will not accept. My warrant will be issued. Kindly, my lord, tomorrow, my man.
No, but then only if you get some stay order.
No.
And if you don't get stay order?
Whatever may be, stay order, my lord, is on merit, your lordship will pass.
Huh.
I need only the notice is issued, my lord. Kindly tomorrow, kindly.
Tomorrow it will not.
No, it's already filed. Matter is already
No,
filed.
doesn't
my lord.
matter. Yes, it is filed, but then you approach the registry because it
My
will be
lord, no,
difficult for the
registry will take time. Kindly, my lord, I approach this honorable. Kindly tomorrow.
Not
If your
tomorrow,
lordship, my lord,
next
that
week.
tomorrow, if
Next
your
week.
lordship allows, my lord, tomorrow it will be listed, my lord. This afternoon.
You were directed to pay maintenance. You should pay.
No, that is different thing, my lord. That is different thing. Just judgment and order I have to challenge before this court. That only I have to show, my lord, in the trial court, my lord. Kindly tomorrow.
I don't think so. I mean, this is not done. I mean,
Kindly.
why did you file it so late?
But that is different explanation. That your lordship will
It's a
consider.
different
That your lordship will accept, my lord. Kindly tomorrow, the matter will be taken. If there is merit, your lordship will issue notice. If no merit, your lordship will dismiss the petition. Kindly, my lord.
Anyway, this court is not sitting tomorrow.
No, but because the mention is for court number 14. All mentions are to be made in this court. So we have come from 14 to here.
Okay, this is as an exceptional case.
All right.
If someone else wants to mention matters for listing, please approach the registry. I cannot. Okay? Yes.
May I please, your lordship? Supplementarily 63 item, lordship.
Supplementary?
63, last item, lordship.
Yes, wait.
She did not receive, lordship.
63.
63, lordship.
Bail hearing, yes,
Bail-
Mr. Sharma.
Any short date may
Okay.
take, lordship.
I heard Mr. A. Sharma, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. Mr. Sharma submits that the case diary has not been received. As such, has prayed for some time. Prayer is allowed. List this matter when? Are you on interim?
No interim, lordship.
List this matter on when can you bring it? 7th of September?
Obliged.
May it please your lordship. Lordship, with regard to item number 24, my lord.
Mm.
Sir, we have filed one additional affidavit, my lord, yesterday. That may be called upon. my lord.
Yes, yes, give the requisition. Yes,
May I please your lordship? Lordship, similar prayer for item number 28.
28.
28. yes,
What?
lordship.
For calling of the affidavit.
Yes, if affidavit in opposition, lordship, that may be
Okay.
brought up.
May it please, your lordship. Lordship, I beg to mention item number 36, your lordship.
Yes,
Lordship, CD is not there. I am on interim, your lordship.
okay. Heard Mr.
A. Rahman.
A. Rahman, learned counsel for the petitioner, and Mr. V. Sharma, learned academician. List this matter on
Lordship, 8.
8 of, are you on interim? No.
Yes, your lordship.
Interim is there, Mr. Sharma?
Yes.
Interim order passed earlier shall continue until the next returnable date.
Highly obliged.
May I please, Lordship? Lordship, in regard to item number 9, Lordship, I want to withdraw, Lordship.
9.
9, Lordship.
9, why do you want to withdraw? Arrested.
No, Lordship, petitioner is not interested to pursue this matter, Lordship.
Okay. Mr.
H. Islam.
H. Islam,
Yes.
but you are not on record.
Ukaratnama is there, Lordship. Mistakenly not show the cause list, Lordship, my name. H. Islam.
You are appearing for, on behalf of Bishina? No. Acha, show
My-
me that, judge.
My name is there, Lordship.
Okay, I'll just check once. Item number 9 to Diana. Haven't 9. H. Islam.
Yes, Lordship.
Okay, your name is there. Okay, Mr. H. Islam, learned counsel for the petitioner, submits that he has instructions to withdraw the matter. Prayer is allowed. Matter is closed as withdrawn.
May I please, your lordship? Your lordship, I beg to mention for listing of a matter which I want to withdraw, your lordship. So, your lordship, may kindly.
Withdrawal.
Yes, your.
Bail application,
No, your lordship, the criminal petition, your lordship.
criminal petition.
Yes, your lordship.
Okay, day after tomorrow.
Highly.
Yes.
Lordship, I beg to mention item 62. We have filed the additional affidavit yesterday.
One, wait, 25th of August. There are 2 lists. Which one? What did you say? Which matter?
Item 62, anticipatory bail,
Supply.
supplementary.
Item?
62.
There is, oh yes, 62, yes, huh. Bail hearing.
Yes, Lordship.
So what happened? The
We
case direct is not there.
No, Lordship, it has not been brought on record. We have, addition-
Acha, okay. Yes, you give the requisition.
obliged.
May I please, your lordship, I beg to state item number 23. Due to inconvenience of my senior's health, he won't be able to appear today. I'll be much obliged if you can adjourn the matter on Friday.
On Friday you want. 23. Admission.
of August.
So Mr. A
23.
Bhattacharya is having some problem. Okay, Miss
Niharika Mitch.
N what?
NMECH, MECH.
MECH, huh? N-match. Learned counsel appearing for the petitioner submits that the conducting counsel has some personal difficulty in doing the matter today and has prayed that the matter be taken up on Friday, that is on 28. Prayer is allowed, list on 28 of August. Okay, 28.
May I please, your lordship? I beg to mention for listing of a criminal petition, lordship.
You go, please.
Challenging NBW, I have filed on 7/8,
It's
lordship.
okay, registry will
Fine.
do it. If they do not do it, you cannot get it listed, then come.
Yes, obliged.
Similar prayer, only my case is that I already approached before the registry. My case was last listed on 14/7/2026, and it was directed to be listed after 2 weeks, lordship. And more than 2 weeks, about more than month has passed, lordship. I have approached them, they have said this, there is no fixed date, so we cannot list it.
So
Bail
what is the
matter-
matter?
Bail hearing, for it will come for
Bail
bail
hearing.
hearing. 2 weeks already passed, lordship.
There was no date fixed in bail hearing matter.
It got fixed. It was only written that after 2 weeks, so that
Okay,
matter.
next week, Monday,
Can it be on Friday? I will be out of session on Monday. Can it be on
this Friday.
This Friday? Special bench, lordship, it will be listed with court number 20.
Okay, this Friday.
of night.
Yes, your lordship. Lordship, I beg to mention for listing of a criminal leave petition, your lordship.
Criminal leave petition, you please approach the registry, they'll do it. You're withdrawing, Mr. Ahmed?
Yes, Lord. Here in this case, already stay order was passed, but before we could communicate the order to the trial court, we are discharged, Lord. under section 255. So this matter will be
So you have challenged charge framing here.
not charge framing, criminal proceeding as well as charge framing, Lordship. And under section 255, after recording some evidences, I was Lordship
Discharged.
acquitted, Lordship.
Okay. Mr. A. Ahmed, learned counsel for the petitioner submits, will not write all this, he will just withdraw. And the stay order will be vacated.
Matter will be closed on it.
Uh-huh. The Mr. Ahmed, learned counsel for the petitioner submits that he has instructions to withdraw the matter. Prayer is allowed. Matter is closed as withdrawn. The rest is not required. The interim order,
Interim order may be recalled.
interim order, passed in the said case stands vacated.
Obliged.
Passed, interim order stands vacated. Interim order date like. I'm suggesting interim order date today. No, like interim order, whatever interim order stands vacated. Yes,
May I please, your lordship, I may be allowed to withdraw this petition with the liberty to file a fresh lordship.
liberty is always there. This is AB.
AB
What he
lordship,
was arrested.
no, not arrested lordship, but here is some documents need to be annexed with this petition lordship. We need to file the fresh along with the annex of some
Okay.
document lordship.
Mr. N.H. Raskar, learned counsel appearing for the applicant, appearing for the petitioner, submits that he has instructions to withdraw the matter. The prayer is allowed with the liberty to file the same if required. The matter is closed as withdrawn.
I know this.
With the liberty to approach this court again if required. Approach this court. Yes.
May I please, your lordship?
Hmm.
Lordship, for 83 bail application, kindly call.
This is motion BA. Okay.
Lordship, kindly call for CB.
What is the offense?
Lordship, 303 sub plus 2.
303 is what?
Lordship will kindly come to page 15.
Huh.
Page 15, Lordship will find.
303 is what otherwise?
theft.
Huh?
Theft.
Theft. Page, where is the FIR? Why page 15 first?
The facts are there, Lordship, for Lordship.
Acha, I'll just go through FIR.
Yes, yes.
So they saw in the CCTV that some unknown person have stolen such bundles of cables, right?
Yes.
So how come you are arrested?
Page 15. Lordship.
Huh?
Lordship, the petitioner has been arrested. only
Your
for-
name is not there?
Lordship, only for.
Enquiry is also done. After completion of inquiry, so I cordially request, okay. Then page 15.
Page 15. Grounds of arrest, point number 2, 3.
He is Biju Roy.
Yes.
Biju Roy is arrested in connection with so and so.
Paragraph number, grounds of arrest, point 2 and 3.
Paragraph?
2 and 3, grounds of arrest.
He was the driver
Yes.
of the aforesaid Tata vehicle used in connection with the transportation of so and so.
And point number 4 also.
But
Lordship.
okay, he was the driver, but when did the occurrence took place? 7:30 AM.
Yes.
No, 7:30 they saw it in the CCTV. When was the theft? When did the theft take place? What time, I mean?
Time is, Lordship, on 7:30 AM.
7:50 AM, this is, we have seen.
Yes, on 6/8/26.
On 6/8/26 morning at about 7:30 AM, we have seen in the CCTV camera that some unknown person stolen so and so from this site by using so and so. The fare. But at what time? You see, he's the driver of the truck. He might not know some cables somebody had had given him money to transport it.
No, Lord, that Lordship will find it at point number 4.
Huh.
Grounds of
During
arrest, point number 4.
himself showed the place of remand where the alleged stolen property had been recovered, thereby providing a material meaning. It's okay, he had taken it to a particular place and he had showed it. Doesn't matter that he is, it will not show that he is involved.
That Lordship, for that purpose, CD will be required to know what has happened after the investigation.
Only he was arrested, no one else.
No one arrested. Lordship, he also helped to investigate
Hmm?
after he has been arrested from police station.
Arrested from?
Police station.
He went to the police station.
He went to the police station.
Why?
Helps investigate.
To help the investigation. Acha, what about when was he arrested? How long he is inside?
He has been arrested on
11/8/26.
11/8.
11/8.
Acha, this month only.
Lordship, today is 14 days.
Huh.
14 days.
But then, okay, he is the driver. Okay. Where have you written that you went to the police station to help the police?
Yes, Lord.
Is it a pleaded case?
Yes, Lordship, he go to police station to helps to investigate.
No, have you pleaded in the petition? Is it there in the petition, that fact?
No,
No.
No,
no.
The fact is not mentioned. Yeah.
not mentioned. Why have you not mentioned in the petition? Had the incident took place at night, okay, even the driver will have some knowledge that maybe it is stolen articles. But then nothing is given. What is the time of the theft? Okay, heard, Mr.
Yes, Alon.
S. Alom,
Yes.
learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application filed under section 483 of the BNSS 2023, the petitioner has prayed for bail in connection with Hualkusi, Soalkusi Police Station case number 44 of 2026 under section 303 within bracket 2/3 within bracket 5 of BNS 2023. The FIR in connection with which the petitioner was arrested was lodged by one Bhaskar Bosho on 10/8/2026 before the officer in charge of Hualkusi Police Station, stating inter alia that on 6/8/2026 at about 7:30 a.m., he and other employees of Shri Gautam Construction Company Limited saw in the CCTV camera that some unknown person stole 4 bundles of UG is capital, UG armored cable wire from the site of the company by loading it on a vehicle that is Tata 712 of Nobonita Road Lines, bearing registration number AS01 RC 1318. Full stop. It is also alleged that the fare to transport the said articles from the company was given to the driver through online transaction. And that the driver was directed to carry the materials by calling in his mobile number. No, in his no. By calling through a mobile number. Full stop. The learned counsel for the petitioner submits that the petitioner is the driver of the said vehicle, and that he was directed to carry the articles by calling over telephone and giving his fare, but he has no knowledge that the articles were stolen articles and that he transported the stolen articles from the company to the particular place. Mr. B. Sharma, learned APP, however, submitted by relying on the forwarding report, by relying on the ground of arrest mentioned in the forwarding report, and stated, submitted, no, he submitted by relying on so and so that stated that the petitioner had the knowledge that the cables were stolen articles and that he helped in that he helped the other mm, other persons in stealing the same and transporting it from the company to the other place where he unloaded. Full stop. Upon consideration of the submissions made by the learned counsel, it is seen that the petitioner was the driver of the truck where the articles were loaded, but it is nowhere stated as to what time the articles were loaded on the truck, and also it is nowhere stated in the forwarding report that the petitioner had the knowledge that the said cables were stolen when it was loaded in the truck, and that he had transported the same knowing that the articles were stolen articles. In view of the same, this court deems it fit that petitioner be released on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of JMFC Hajo under the following conditions. Appearance, appearing before the IO as and when called. Petition is disposed of. Yes, Mr. Ahmed.
May please lordship, the substituted case lord, the petitioner is the absconder and the NBW against the episode, and then Ellis, he is the behind the bar till now 85 days lordship. The law trial court rejected the bail clear lordship.
What is the offense?
366 lordship, the page
Kidnapping.
14 lordship. I read lordship, the Hanman Purbak Vinit Nivedon Eje, Zua Ingraje 17/7/18 তারিখে রাতিপুৱা অনুমান 10টা মান বজাত মোৰ সৰুবন্দি মুনিয়াৰা খাতুন বয়স 18 বছৰ 6 মাহ 18 বছৰ 6 বজাৰত তাইৰ ব্যৱহাৰিক সামগ্ৰী কিনিবলৈ আহোতে 1 নম্বৰ আসামীয়ে বিয়া কৰাৰ প্ৰলোভন দি 2-3 I am the thrill আসামীৰ সহযোগত মাৰুতি গাড়ীত তুলি অজ্ঞাত ঠাইত নি লুকাই ৰাখি আজি ইংৰাজী 22/7/18 তাৰিখে 2 নম্বৰ আসামীয়ে সোৱানচু ফোনেৰে ফোন কৰি জনাই যে 3 নম্বৰ আসামীৰ ঘৰত হাজাৰটাৰিত আছে I am the
3 number.
অহা ইংৰাজী 23/7/18 তাৰিখে মোৰ ভণ্টিক গুজৰাটত লৈ যাব মোৰ সন্দেহ হয় আসামীগণে মোৰ ভণ্টিক গুজৰাটত নি দেশ ব্যৱসায়ীৰ বছৰত বিক্ৰী কৰিব মোৰ ভণ্টিৰ লগত 25,000 টকা আৰু ইন্ধনত কমেও 15,000 টকা কোন ৰূপত অলংকাৰ আছে
So the victim was kept at your place. And the the accused number 2 called up and said that you will take her to Gujarat. You, PW3.
No.
Who will take her to
Hey,
Gujarat?
Lordship, the request number 1.
More bhante Gujarat ole loi jabo.
Lordship, any condition that I face the trial, Lordship.
But this is too much. Let the case diary come.
TCR. Lordship.
Oh, it's here.
Already 85.
See,
Not about it.
in the earlier case, okay, but there are, it is not sure as to whether he stole. But here you see, it was kept in your house. She was kept in your house.
The request number 2 and 3 are the relatives, Lordship.
2 and 3.
Brother-in-law of the request number 3, petition.
Let the TCR come.
Lordship.
Allegations are
Any
serious.
condition-
Selling someone. No,
Already-
any condition is okay.
Judicial custody,
Team
85 days on
team has been
the-
examined or not, Lordship, because
Yes.
trial was stopped
Lordship.
because of his non-appearance, Lordship.
I
Thereafter,
have
he
no
was arrested.
knowledge
on-
about the pending of the case, Lordship.
No, heard
Chapter
Mr.
control, Lordship.
Heard
Mr.
Mr.
TCR.
N. Ahmed, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Sessions Case number 56 of 2026, registered under section 366, read with section 34 of IPC, pending before the Session Judge Borpeta, arising out of Colgacia PS case number 657 of 2018, under section 360, 2018, full stop. Call for the trial court records, scan copy. Call for the scan copy of the trial court records. List this matter after 2 weeks. List this matter on 14th of September.
Second, Lord, already 85 days.
This year though, it will take some time for it to come.
2nd September, Lord.
Ahi na paye.
From Hajo, it will come.
Borpeta.
Place?
Borpeta.
Borpeta. So,
On second,
7th of September, Monday. Okay.
Yeah, Lordship, charge sheeted matter.
Charge sheet.
My lord, I'll briefly state the facts. My lord, having been arrested on 8/6/26, my lord, presently he is behind the bar for last 79 days.
8/6/26.
8/6/26, my lord.
Okay.
Now what has happened,
Mm.
my lord, the alleged occurrence took place on 24/3/26. And my lord, the informant lodged the FIR on 1/4/26 with 7 days delay. I'm not on that, my lord.
Mm.
My lord, the informant is the father-in-law of the petitioner. He alleges, my lord, that the marriage took place in the month of August 25. And after the marriage, my lord, on search of employment, he, my lord, went to Bangalore. These are admitted facts, my lord. And after his departure, the daughter, my lord, came back to her parental house. Thereafter, she is residing there. My lord, the informant proceeds to allege that from time and again, the family members and the petitioner demanded money. And thereby, my lord, inflicted mental and, my lord, physical injury. That
So
is the
for
allegation.
UTAT,
No, my lord, it's a case of 80 subsection 2. My lord, on the date of occurrence, the allegation is that there was an interaction over phone, my lord, between the accused petitioner and the daughter. And he says, my lord, that something, my lord, unwanted, he told something unwanted to her and also demanded dowry over phone. Thereby, my lord, she committed suicide. This is the entire allegation. Now, at the time of her death, the accused petitioner was admittedly at Bangalore. This is the case of the informant himself, man. And over telephone, some interaction took place. So, my lord, she committed suicide. So, entire, my lord, the case of the prosecution is this, man.
so abatement can also be done through telephone, may not be present at the place of occurrence. Is a case of abatement.
My lord, it's
Yes.
a case of abatement. They are trying to make out like a case of abatement. What I'm trying to say, my lord, that after, my lord, she came to her house, my lord, in fact, against her will, the marriage had taken place. My lord, 2-3 paragraphs, if I
Okay,
take
I'll
your
just
lordship.
read the FIR 1 second.
Yes, FIR, my lord, your
Page
lordship will find at
23.
page 23.
Okay.
And here, my lord, there is a typing mistake in the FIR.
Mm.
My lord, what has happened, your lordship will find 2 sets of documents. FIR and charge sheet, my lord, the date of marriage is correct, 6/8/25. And the other documents regarding arrest memo, etc., they have, my lord, recorded the date as 6/8/26. 6/8/26. Incident took place on, my lord, 24/3/26. So all are anterior, my lord, anterior.
Acha. Okay, I'll read the
Yes, yes,
FIR.
madam.
FIR translation is okay, right?
Translation is okay, but here only one date is malad wrong. It should be 26, 25, man. This Ejahar is to the effect that on 6/8/26, it should be 25. Because in the FIR, my lord, that date has been correctly written, man. My daughter Hamida Yasmin was married to the above mentioned accused number 1 in accordance with Islamic Sharia laws. At the time of marriage, despite giving dowry items and goods to the best of my ability, all the accused persons, my lord, accused persons are my lord, the family members. Only accused number 1 is before your lordship, my lord. All the other accused persons were not satisfied with the same and raised the demand of an additional amount of 2 lakhs in cash as dowry and tortured her both physically and mentally upon my daughter. While my daughter was enduring all the torture inflicted by the accused person, on 23/3/26, my lord, around 7 p.m. in the evening, accused 2, 3, 4, and 5 physically assaulted my daughter, demanding dowry money. And as per instruction of accused number 1, accused number 2 dropped my daughter, that is not the petitioner, my lord, the accused persons, in front of my house and went away, telling her to return only if she could bring the dowry money. Finding no other way, my daughter came inside my house and narrated the entire incident. I sought justice from the villagers about the matter. Under such circumstances, on 24/3/26, it is the date of occurrence, my lord, at about 1:40 p.m., accused number 1 made a phone call, that is the petitioner, my lord, from Bangalore, from mobile phone number so-and-so to my daughter's mobile phone number so-and-so. He used abusive language with my daughter and insisted pressure on her to bring the demanded dowry money as per his demand. Being unable to bear his torture, and upon considering my financial position, on 24/3/26 at around 1:40 p.m., closed the door of my storeroom and tried to commit suicide. She was not seen for quite some time. We started searching for her here and there. Not finding her anywhere, we suddenly went towards my abandoned storeroom and found the door closed from inside. I forcefully opened the door and found my daughter hanging. Hearing my scream, nearby residents and local villagers rushed to the spot, rescued her, and immediately took her to the Karimganj Civil Hospital for treatment. This is, my lord, the allegation, man.
Acha, this is what, on 23/3, that is one day prior,
My lord.
in the 23/3, 7 p.m., in the evening, 2, 3, 4, okay, and as per instruction of 1. 1 means from Bangalore.
Bangalore. They say, my lord, from my instruction.
Dropped my
Yes.
daughter in front of my house and went away, telling her to return. 2 is otherwise who? Abdul Mani.
2, my lord, he is the
Brother.
father. He is the father.
Father.
Father has been exonerated by the charge sheet, my lord. 3 is Rimi Begum. She is the mother. Now she is, my lord, in the charge sheet. 4 and 5 exonerated. So by way of the charge sheet, 1, my lord, and 3, they are, my lord, implicated. And 1 is before your lordship today. 3, my lord, 3 Rimi Begum,
So
who is
accused number 2 dropping the doctor is not believed by the police.
no one
So that instruction also goes.
goes, my lord. And lordship,
How
but
come 3 is implicated?
my lord, I don't know. In fact, 3 has been granted bail by the court below, my lord. She's on bail.
No other
My lord,
way,
my respectful submission is, presently, my lord, he has incarcerated 79 days. Now, my lord, the prosecution is not going to achieve anything by this continuous, my lord, incarceration.
Yes, yes.
Because otherwise,
Ah.
my lord, this is a case of death, I admit, my lord. But
Oh, 80 is dowry debt.
dowry debt. But your lordship will kindly see, my lord, the manner and method by which the offense is committed is a prime consideration, man. If the
Dowry debt is difficult to prove. All those 4 ingredients has to be proved, right?
yes, my lord.
Okay, heard Mr. S.K. Talukdar, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Sri Bhumi PS case number 75 of 26, corresponding to Sessions case number 112 of 2026, registered under section 80 within bracket 2 of the BNS 2023. Mr. Talukdar, learned counsel for the petitioner, submits that the petitioner submits that the petitioner and the victim got married on 6/8/2025, and thereafter the petitioner, in search of employment, went to Bangalore. Full stop. he submits that the allegation made in the FIR is concocted one. And that oh no, before that, I forgot. Yeah, the FIR, the first information report in connection with which the petitioner was arrested, was lodged by the father of the victim on
On my lord, 1/4/26.
on 1/4/2026 before the in charge Longai police or patrol post, stating inter alia that his daughter was tortured after her marriage with the petitioner, that is accused number 1 in the said FIR, and that dowry was demanded from her. Full stop. It is further alleged that on the instruction given by the petitioner, the father of the petitioner dropped his daughter in front of the house by stating that she should return only after she brings the dowry money. Full stop. It is also alleged that on 24/3/2026, at about 1:40 p.m., accused number 1, that is the petitioner, made a phone call to his daughter and scolded her over phone and pressurized her to bring dowry money from her father's house. And that being unable to bear the torture, it is alleged that the victim entered the storeroom and locked it from inside. And upon search being made, the father and other family members went to the storeroom and broke open the door and found that her daughter had hanged herself. Full stop. It is further alleged that the victim was taken to the hospital and she was declared dead. The learned counsel for the petitioner submits that both the petitioner and the victim was married on 6/8/2025, and that day petitioner went to Bangalore in search of jobs, and the victim wife and the alleged and his wife went to her father's house to stay during his absence. Full stop. He further submits that the story narrated in the FIR is a concocted one, and it cannot be believed that the phone call given by the accused number 1, that is the petitioner, to his wife had forced his wife to commit suicide. Full stop. He further submits that the police has completed the investigation and charge sheet was submitted only against the petitioner and his mother, and that the police had discharged the father as well as other relatives of the petitioner. He also submits that the mother of the petitioner was enlarged on bail by the trial court itself.
Yes,
By
yes,
the
ma'am.
trial court itself.
I have annexed the order.
It's okay.
Madam.
On the other hand, Mr. B. Sharma, learned APP for the state, submits that the allegations are writ large in the FIR about demand for dowry, as well as the phone call made by the petitioner to his wife, wherein the wife was abused and was forced to bring the dowry money. On consideration of the submissions made by the learned counsels, more so in view of the fact that the father of the petitioner was discharged, who was stated to have dropped the victim at her place on the day before she committed suicide, And also the fact that on the phone call made by the petitioner, it cannot be discerned that the victim would commit suicide. This court deems it fit, this court deems it fit to enlarge the petitioner on bail. And also that the petitioner has been inside the jail for
79 days, Malad.
around 79 days. This court deems it fit that the petitioner be released or enlarged on bail on furnishing of a bail bond of rupees so and so, to the satisfaction of
Additional Session Judge Sri Bhumimal.
additional session judge Sri Bhumi under the following condition.
I'm deeply.
Petition is disposed. Yes.
May I please, your lordship? File one poster is bill application, lordship. Lordship.
Arrested on
Sections-
5-8.
Sections involved, lordship, 64,
64 is what?
punishment for rape.
Rape.
Yes, lordship.
87.
87, kidnapping,
87 is
abducting.
promise to marry.
Yes, no, kidnapping, abducting, or inducing women to compel marriage, lordship.
Acha.
But
Where is the FIR?
as far as in page
Maybe they were in relationship. What?
yes, exactly, lordship. They were in relationship.
The victim is the informant.
No, mother of the victim is the
Mother.
informant, lordship.
Okay.
Because they were in relationship, that's why, lordship, the victim, she refused to file an affair against the accused person, lordship. That's why the mother, she filed an affair, falsely alleged affair.
I'd like to inform you that on 3-8.
FIR is in page number 10, lord.
Okay, I'll read it myself. Okay, then
Lordship, actually what happened, lordship, is that the victim and the accused person both were in relationship, lordship.
where do you say it? How do you say that? Anywhere?
In Annexer 4, lordship. In
It-
Annexer 4,
Where is the forwarding report?
forwarding report is in page number
15.
15, lordship.
Okay, I'll read it, wait. So victim had given a statement. Hmm?
Victim have given a statement on pressure of the mother, lordship. But if you go through Annexer 4, lordship, you can see all the documents
These
here.
are the WhatsApp messages.
Yes, lordship. In
Shiva.
21 page number, you can see even she shares her photos and all. And moreover, your lordship, on 28, lordship, if you see page number 25 of the annexer, your Honor, on the first part and on the last part, you can see they were in relationship, lordship. But only on the pressure of the mother.
Let the case diary come or the what charge sheet submitted,
No, not lordship.
because we have to see the victim statement.
From Jalukbari.
Otherwise, it's not clear.
From Jalukbari.
Only these WhatsApp messages we cannot rely, because whether it is him or her,
No, it's
right?
true, your
Although it's
lordship,
written Shiva, but
lordship,
we'll fix a short date. We will see the victim statement. Do you have the victim statement?
no,
You
we don't.
cannot have, right?
Okay.
So let the case diary come.
But lordship, the thing is that simple. They both were in relationship. What happened, your Honor? Let me.
But in the forwarding report, nothing of that sort has come into picture. Only that her statement needs some corroboration, that is stated by the police. Had it been totally believable, the police would not have said, this is okay, that can be a ground. But police also, you cannot expect them to know everything.
Yes, exactly.
So
Yes, your
let the
lordship.
case study come. We will fix a short one where it is from. Kamrup only.
Jalukbari,
Right.
Jalukbari.
Jalukbari PS.
Okay, heard, mister?
Lordship, but I want to speak something about. Lordship, they were in relationship, and only because she was not willing to file an affair, that's why her mother, she
No,
filed an
how
affair.
can how can I deduce that? You have placed only WhatsApp statement anywhere where I can see that they were in relationship.
On page number 24, that's what I
That's
have
what, that's the only thing.
on the first part and the
Yes.
last part of the.
That's the only thing, but
But
never know
Yes,
she is a
to-
college going girl.
yes,
Of course, she is major, 19.
yes, 19 lordship.
But the allegation is that the person lured her, took her to his home,
No, that was not the fact. The fact is
from the
it was
college
not
to his house and, but okay, nobody will go to an unknown person to his house.
exactly. She was
That
not.
is,
Let me speak, lordship. She was not feeling well. She called her boyfriend. Please meet me up outside college or something. He came. Then she.
these are the story that you know or your client have said you. But
He
then
said,
this
my client is.
court cannot deduce, has not found out all this. So only one thing that she will not go with a stranger. Here in the
Exactly.
ground of arrest, it is stated, victim specifically named and identified the accused person as if they were not in relationship. Huh.
Exactly.
As the person alleged to have committed the offense. But with a stranger, a person will not go to his home
Not
from the
good,
college.
exactly.
So
And
then let's see these.
She asked her to take her to her home because
It's
she was
okay.
having
Heard, Mr.
M.
M.
Das.
Das. M. Das, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Jalukbari PS case number 305 of 2026, registered under section 6487 of BNS 2023. Call for the case diary.
Date may be fixed, lordship.
List this matter on,
31st.
when can you bring? 3rd of September?
31st, Lordship. Next
Or-
week, Monday.
Monday, 31st of September or August? You try it on 3rd of August, 3rd of September. Oh, 31st, yes, yes, yes. 31st is before that, my God. 31st of August.
Obliged.
Yes.
What
What is 140? What is section 143?
Lordship, section 143 has been, but this section will not come because.
What is 143?
143 is, 140, section 3 is abduction, but it's
Abduction.
minor. So probably section 137 will come.
Okay, where is the FI?
Lodge. Type copy that page, Lordship.
Page 13.
Page 13.
Rupali Das. Nikhil now. Morning 11 AM.
Lodge.
Girl was taken away.
Lodge. Incident occurred on Lordship 18 in the morning.
Mm.
Then Lordship will find at page 15. The, the vernacular portion Lordship. It was lodged on 17, 19. FIR was lodged on
19.
19. Then Lordship will head to the next phase. The FIR has been registered on 21st of July. After 5 days, Lordship.
Maybe some inquiry was done.
No, Lordship. Actual fact is that what I'm instructed by the client is that this petitioner, parents of this victim, they themselves Lordship, sent her daughter along with this petitioner to sightseeing in Calcutta, Lordship. Because during that time, vacation was going-
Sightseeing in
Lordship,
Calcutta?
because Lordship, his maternal uncle house is at Calcutta, this petitioner's house.
Ah.
So he regularly visit Calcutta.
Mm.
On that occasion also, Lordship, their parents Lordship sent her daughter along with this petitioner. Because they are neighbors.
Mm.
This victim called her Moha.
Mm.
So Moha Lordship. So there is a good relationship. Therefore, Lordship, after might be lordship, there might be some dispute between this husband and wife. And accordingly, this affair has been lodged. Actual fact is that. They themselves allowed their daughter lordship to accompany this petitioner to Calcutta.
Page
But-
18, lordship will kindly come.
But where
Yeah,
can I deduce those facts, huh?
Page 18,
Page
lordship,
18,
for a
yes.
moment.
18 is what?
18 is the bail rejection
rejection
order
order.
that lordship will find.
Oh, you have filed this AB before
Yes, session.
session judge?
Lordship will kindly come to paragraph number 3.
Hmm.
Call for the case diary so and so. Number 1, during investigation, it reveals that the accused took the 13-year-old victim to West Bengal on the false pretext of casual outing. Considering the huge age gap between 40-year-old accused and the minor victim, the circumstances prima facie indicate a well-planned conspiracy. The act of taking a minor victim outside the state on false assurances raised a strong suspicion of trafficking or her involvement in illegal activities for the personal gain of the accused. Now, Lordship will kindly come to the next page, page 19. Paragraph number 8, Lordship will see. Paragraph number 7, first, Lordship. In the 4th or 5th line, Lordship will find the accused Nikhil Nag kidnapped 13-year-old daughter, namely so-and-so, and was hiding her in an unknown place. Having come back from work, they didn't see their daughter at home, and after checking the market CCTV, they saw the accused take her away.
It's difficult to believe. Market CCTV.
Market CCTV?
CCTV that was installed in the market
Yes.
by taking the help of traffic police.
But that will be revealed from the case
With
diary,
some
Lordship.
personal
Yes, that
shop.
may be so. They may have traced out. Now, let's paragraph number 8. From the birth certificate reveals that the victim was about 12-13 years of age at the relevant time, and therefore she was a minor. Further, from the statement of the victim, it reveals that the accused is a married man and that he had taken the victim to West Bengal with promise to marry her in the future. There is prima facie materials of inducement to lure a minor victim. Moreover, the investigative agency is trying to find out involvements of other persons and suspected it to be a case of human trafficking. So at least, Lordship, the CD will be necessary. Lordship.
You will have only the one line is there, lordship, she was taken away, that's paragraph 8.
But the
Last line
CD was seen by the court.
Yes.
Entire materials available. I have perused the entire material, including the birth certificate.
Yes.
Statement of the victim was there. It revealed that the accused is a married man. He had taken the victim to West Bengal with promise to marry her in the future. Maybe there it is voluntary, but she must have also gone with him with the. But then she is a minor girl.
She is a minor girl. We are not denying lordship, she is a minor girl, but she was allowed by her parents itself. lordship.
That has not come out in the
This- in the order, lordship.
neither in the case record.
No.
It is not
Only one line
reflected.
is that lordship, that this prima facie materials engagement to lure a minor girl is fictive. That line is there.
Which
Nothing-
one? Which one?
The last line of paragraph, page 19, lordship.
Last line of paragraph?
Page 19, paragraph 8.
Yes. Moreover,
that line,
there is
prima
prima facie
facie.
materials of inducement to lure a victim. Moreover, the investigating agent trying to find out.
Lord,
So,
Yeah.
let the
at
case
this,
diary.
I may be allowed in PS.
Case diary had already
I-
come and it was seen.
It was
Okay,
seen.
let us see her statement.
Lordship.
Lordship, for-
Otherwise, had he taken it to some other nearby places, okay.
No,
from
because he
Assam to
regular- no,
Calcutta.
he regularly visit to Calcutta.
Doesn't matter,
In my petition also I have stated, that he
It's
regularly
okay.
visit. Yes.
Third, Mr. J. Kolita, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has prayed for pre-arrest bail in connection with Goresar PS case number 48 of 2026, registered under section 140 within bracket 3 of the BNS 2023. Call for the case diary. Where it should come from which place? Goresar. Okay, list this matter on 3rd of September?
Lordship.
3rd of September.
In the meantime,
And let us see, and then we'll finally pass the order.
in subsequent time, Lordship, if Lordship have any materials, Lordship has the opportunity to reject my petition. Lordship.
Rejection and,
I will not.
no, rejection and allowing are two different things. I'll see and don't worry, he will not get arrested within these days.
On that.
What is 316(4)?
Criminal breach of trust by clerk or employee.
Criminal breach of trust. Okay, where's the FIR?
FIR is page number 9.
He had borrowed some money.
No, Your Lordship, he is an branch head of a Arogya Financial Institution.
Why the FIR to superintendent of police?
I don't know, Your Lordship, why.
His FIR was not registered or what? Okay,
It is
I'll read
registered.
the,
It is registered.
okay, I'll read the, this FIR myself. Madhu Bora. Okay, so he himself admitted.
No, Your Lordship, it was taken on by coercion, Your Lordship. By force.
So what else you wanted?
I may be allowed to appear before the IO. Let me, quote my statement. And if I charge it, I will face the trial.
So certain things are seized also.
Yes, Your Lordship. All documentary evidence, it has been seized. So there is nothing that I can hamper with the evidence.
Self-declaration by Madhu Bora.
Yes, that has been seized.
Hmm.
It is mentioned in the FIR also. Let the CD
Yes.
of Lordship
You have moved a bail application
Yes,
for.
yes, Your Lordship.
rejected.
It was rejected. Page number 19, Your Lordship, annexure 3.
Gravity of the materials, but what materials it is not specified.
I pray
Lordship,
for interim protection,
From Nagaon, Lordship will produce the case die next week, Lordship.
so that I can appear before the IO.
So this 7,79,000 is inclusive of 3 lakhs.
No, Your Lordship.
Remanding refunding 3 lakhs by 30th June
Yes.
That was the undertaking, Your Lordship.
and the remaining amount next 10 days. And this 7,79,000 includes that 3 lakhs.
Yes,
No.
yes,
No,
Lordship.
no, Lordship, it
Yes,
doesn't
Lordship,
include.
that undertaking
On the
was taken.
same day, a physical cash verification was conducted. Cash shortage of so-and-so was identified. That is irregularities.
9,300.
Maybe it is inclusive of that.
Yes, Your Lordship, it's inclusive. So I'll be protected, Your
Okay,
Lordship.
heard Mr.
Yes, Decca.
S. Decca, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has prayed for pre-arrest bail in connection with Nagaon PS case number 522 of 2026, registered under section 316 within bracket 4 of BNS 2023. The FIR in connection with which the petitioner is apprehending arrest was lodged by the representative of Arohan Financial Services Limited on 30/6/2026 before the Superintendent of Police Nagaon, alleging inter alia that the petitioner is an employee of the
Is a
stating
branch
inter alia, that the Arohan, that the complainant is the Gautam Das. Oh yes, that he is that he is the authorized representative of Arohan Financial Services Limited, having its registered office at Kolkata as well as at Nagaon, and that the petitioner is the employee of the said organization, and that he was entrusted with the sole custody and responsibility of the cash kept in the said branch. Full stop. The informant states that the petitioner had illegally utilized the company's money for his own personal purpose, and that a discussion was held with the petitioner, and during the said discussion, the petitioner had acknowledged the irregularities committed and promised to return part of the money within a stipulated period of time. Full stop. Oh, we refunded, not part. Refunded, he promised to refund the money. Full stop. It was also alleged that the cash amount of rupees 7,79,373 was found to be short while verification done in the said branch. Learned counsel for the petitioner submits that the acknowledgement made by the petitioner was forcibly taken by the informant, and that the informant was no way responsible for the shortage of the money found in the branch. But he is the one who is actually looking after the cash now. He cannot say that I'm not.
What happened in this case, Arohan Financial Service, they provide loan to the beneficiaries. Now, on record, it is shown that all entire money has been recovered from, but in reality, that loan amount has not been recovered from the market units.
He further submits that the said company used to provide loan to the customers, and that it was nowhere provided that the loan amount has been repaid by the said customers. And as such, a shortage of some money was detected with the branch. Mr. B. Sharma, learned APP, however, submits that the petitioner is given the sole responsibility of maintaining cash in the said branch, and that the petitioner had never stated that the amount was given in loan to the customer, and that a shortage of money was detected,
So he's the branch head.
and that the petitioner was the branch head of the said branch at Nagaon. Upon consideration of the submissions made by the learned counsels, it is seen that apart from the self-declaration made by the petitioner, no other materials is shown to have been collected or known to the informant. It is also stated by the informant, for full stop. The further statement made by the informant that a physical cash verification was conducted and a cash shortage was identified, but it is not stated that the said short by any other witnesses that the shortage was due to the conduct of the petitioner. As such, this court deems it fit. Okay, you submit your things before the IO. Deems it fit to enlarge the petitioner on pre-arrest bail, not interim, pre-arrest bail, on furnishing of a bail bond of rupees 30,000 with one local surety of the like amount to the satisfaction of the arresting authority under the following conditions. The petitioner will appear before the investigating officer within a period of 7 days from the date of the order and would furnish all the required documents for proper investigation of the case. The petitioner will not influence the witnesses, all those will be there. And on failure to appear before the investigating of Baki condition date that he will not leave his place of residence without the permission of the investigating officer. After that, you write on failure to appear before the investigating officer or on failure to comply with the conditions, the said bail order would be amenable for cancellation. Petition is disposed of.
Obliged.
Hello, sir. The dispute of a matter boundary line.
Boundary. Fight between two parties.
Page 13, madam. Page 13 is a particular option, madam. The main accused is Orup Sutia, madam.
And 115, 118, 351. What are these?
I am not, the allegation is against Orup Sutia, madam. This is accused number 1. I am not on Orup Sutia.
You are Madhu Bharali.
I am Madhu Bharali and madam Pallab Sutia. Pallab Sutia is a madam juvenile. And madam, there is no allegations against
Madhu Bharali is there.
Madam?
In
Allegation is
the area of
Madhu
accused
Bharali
persons.
attacks son of the madam.
Okay, I'll
the
just read
informant,
it.
madam.
I'll read
Madam,
the
where is the
F5.
son madam has not been medical, has sent to medical.
Okay, I'll read the F5 myself here.
Madam, Page 13, madam, is the version of it.
Page 8. Page 8 is
Kindly look at the vernacular.
or not proper.
That's not proper.
The translation is
Translation is
not
not
proper.
proper.
Okay,
Married, no?
okay, then you have to read. Pratham Pakha is the informant. 15/8.
Fif-
So
15.
when is the FIR lodged? 15/8.
15. My accident took
Same
place
day.
on the same day.
তারিখে পুয়া 8 মান বজাত আমার বাড়ি
আমার বাড়ি হিমা ঠেলি দ্বিতীয় পক্ষে নেউৰা ভেটিছিল।
So দ্বিতীয় পক্ষ include you also, Madhu Bharali.
মানে দ্বিতীয় পক্ষ মানে অৰূপ ছিল। মই কাইলৈ ওলাই নেক্সট মানে।
And then
এই বিষয়ে দ্বিতীয় পক্ষক সোধা পোছা কৰাৰ লগে লগে দ্বিতীয় পক্ষৰ শ্ৰী অৰূপ চুতীয়া এডাল বাঁহৰ লাঠিৰে মোৰ স্বামী শ্ৰী পুতুল ভৰালীৰ মূৰত মৰিয়াই পেলাই দিয়ে। তাৰপিছত এখন খামটিৰে ঘটিয়াই দেহৰ বিভিন্ন ঠাইত গুৰুত্বপূৰ্ণভাৱে জখম কৰে। দ্বিতীয় পক্ষত উল্লেখিত শ্ৰী মধু ভৰালী এডাল লাঠিৰে মোৰ স্বামী আৰু পুত্ৰ বকুল ভৰালীক আক্ৰমণ কৰে। মানে দিছ ইজ লাইন শ্ৰী মধু ভৰালীয়ে লাঠিৰে কৰা আক্ৰমণত মোৰ পুত্ৰৰ দেহত কেইবাটাও ঠাইত জখম হয়। দিছ দ্য এলিগেশ্যন। তদুপৰি দ্বিতীয় পক্ষৰ শ্ৰী পল্লৱ চুতীয়াই মোৰ স্বামীক এখন চোকা অস্ত্ৰৰে আঘাত কৰাত গুৰুতৰভাৱে জখম হয়। সংকটজনক অৱস্থাত মোৰ স্বামী শ্ৰী পুতুল ভৰালীক ঢকুৱাখানা চিকিৎসালয়লৈ নিয়া হয় যদিও চিকিৎসকে ডিব্ৰুগড় মেডিকেল কলেজলৈ উন্নত চিকিৎসাৰ বাবে প্ৰেৰণ কৰে। মানে এলিগেশ্যন ইজ মানে ৰিলেটিং টু মধু ভৰালী মানে এলিগেশ্যন ইজ he attacked his the informant son of the
Madhu Bharali had also attacked her Swami, her husband and son. Madhu Bharali
he is a relative of the mother Orup Sutia mother.
Doesn't matter, but then overtax are mentioned. Lathire kora akramonot mur putro dehor.
This son was not sent to medical again.
Okay, but then he attacked her husband also.
Husband not is not just to mother implicated mother. These are relative matters. They no way connected with the matter boundary dispute matter.
Okay, so
Petition number 2 matter is a juvenile one. The
Madhu Bharali.
Pallab Sutia.
Oh, you are mentioned. You have filed it on behalf of two persons.
Two persons.
So Madhu and
Pallab Sutia. Pallab Sutia is juvenile matter.
Pallab Sutia is juvenile, so his case can be placed before the.
Matter police has matter touching and matter.
He is admittedly juvenile.
17 years, my lord, 8 months.
17 years,
Yes,
8
yes.
months.
At the page 14 is the birth certificate. His date of birth is 22/11/8. 17 years, 8 months. That's why police are searching.
Okay, heard Mr. A. Khoniker, learned counsel for the petitioners, and Mr. B. Sharma, learned APP for the state. By this application, the petitioners, namely Madhu Bharali and Pallab Chutia, have prayed for bail in connection with, have prayed for pre-arrest bail, in connection with Ghilamara PS case number 39 of 2026, registered under section 115, within bracket 2, 118, within bracket 2, 351, and 35 of BNS 2023. The FIR in connection with which the petitioners are apprehending arrest was lodged on 15/8/2026, wherein the informant had stated inter alia that there was a dispute regarding the boundary between two families, and that on the day of occurrence, accused number 1, arrayed in the said FIR, arrayed as such, in the said FIR, Mr. Arup Chutia. Oh, he is son of Arup Chutia, no? Pallab Chutia.
Chutia is his son.
Son, father and son.
Father.
Arup Chutia.
Morubal is nowhere, madam.
Good name. Hit her husband with an cane stick. Hit her husband on his head with a cane stick. Full stop. On a cane stick, and that he had also. তাৰ পাছত এখন খামটি দ্বাৰে ঘপিয়াই দেহৰ বিভিন্ন ঠাইত গুৰুতৰ, and that the said accused person had also assaulted her husband on his various parts of the body. Full stop. The informant had also alleged that the petitioner number 1 had attacked her husband and her son with a stick, and that petitioner number 1 had assaulted her son and that her son had received injuries. Allegations were also made against petitioner number 2 that he had attacked her husband with a sharp weapon, causing injuries. Full stop. It is further alleged that the husband of the informant was taken to the hospital and thereafter to a local hospital, and thereafter to the medical college for better treatment. The learned counsel for the petitioners submits that the husband of the informant was injured, and there is nothing in the FIR wherein petitioner number 1 is stated to have caused injuries on the husband of the informant. He also submits that petitioner number 2 is a juvenile, and that there is no allegation that petitioner number 2 had hit. No.
Allegation is there.
More Samik. Oh, okay. That you don't put up. He is a juvenile. And he submits that under the Juvenile Justice, within bracket, care and protection, Juvenile Justice Act, what is the full name of the act? Juvenile should be enlarged on bail, only with the exception that that the same may not be allowed if there are chances that he will go and meet other accused persons. Full stop. Mr. B. Sharma, learned counsel for the state, however, submits that overt act, OVERT, overt acts are attributed to both the petitioners and that the husband of the informant received injuries. On consideration of the submissions made by the learned counsels and on seeing the fact that it was the husband of the informant who was taken for treatment, and there being allegation that accused number 1, arrayed as such in the FIR, had hit the husband.
He was already a statement, he signed a report.
Husband. This court deems it fit that petitioner number 1 be released, be enlarged on bail, be enlarged on pre-arrest bail. Full stop. It is also seen that petitioner number 2 is a juvenile and there is nothing on record to show that he will go and associate himself with other accused persons. This court also deems it fit to enlarge the petitioner number 2 on pre-arrest bail. As such, both the petitioners are directed to be released on pre-arrest bail on furnishing of a bail bond of rupees 20,000 each, with 1 local surety each, to the satisfaction of the arresting authority under the following conditions. They will appear within 7 days and they will not those conditions. They will not leave the place of residence without the permission of the arresting authority. Petition is disposed of.
Next is your lordship, it's a pre-arrest bail.
What is 303(2)?
This is theft, your lordship.
Theft.
Theft. Brief facts of the case is such that
Where is the FIR?
FIR is that page number 10, your lordship.
Page 10.
Page
What
10.
is your name? Jabbar Ali and another.
Yes.
Jabbar Ali, and what is the other person's name?
Her name is Nanija Bibi.
Nanija Bibi. Husband, wife, or what?
No, husband, wife, both are.
No. Jabbar and Nanija Bibi. These are the 2 accused persons
Yes, your
in the FIR.
Yes.
Okay, I'll read it myself. Wait. (23)(3). There are 7 days delay. What? His mobile phone was lost.
Yes.
Then how could he remove the SIM card?
He applied for a new SIM, lordship. That is from the translated vernacular one, lordship will find.
Vernacular is better.
Yes. Page 17, lordship, second paragraph.
Acha, read the vernacular.
Yes.
এজাহারকারী সম্মানপূর্বক নিবেদন এই যে
Just a minute.
তারিখে রাতি প্ৰায় 23
10:10 বজাত
মই ডবকা বজাৰত বজাৰ কৰি থকা অৱস্থাত মোৰ পকেটৰ পৰা মোবাইল ফোনটো হেৰাই যায়। মোৰ মোবাইল নম্বৰ ইমান পৰৱৰ্তী সময়ত মোৰ মোবাইল ফোনটো বহুত বিচাৰো যদিও বিফল হৈ ডবকা থানাৰ বিষয়া মহোদয়ক এজাহাৰ কৰো যদিও কোনো সঁহাৰি পোৱা নাই। পৰৱৰ্তী সময়ত মই একে মোবাইল নম্বৰৰ
নম্বৰৰ SIM card
লোৱাত
So when-
Eke number SIM card uluat.
Because
He will be able to get his past transactions.
the report, SMS will come, Lordship, because the mobile number is connected to
Same.
the account. The
Huh.
mobile number is connected to the account.
Ah.
So any messages that was there, it will automatically come, Lordship.
Oh. মোৰ মোবাইল নম্বৰ একে মোবাইল নম্বৰৰ চিম কাৰ্ড ওলাওঁতে গম পাওঁ যে মোৰ ফোনৰ পৰা উপৰোক্ত ইমান তাৰিখে টকা মোৰ অজ্ঞাতে ওলোৱা হয়। মই দুখীয়া পৰিয়ালৰ লোক হয় আৰু বহু টকা মোৰ একাউণ্টৰ পৰা দুষ্কৃতিয়ে আত্মসাৎ কৰা মই বহুত okay. Gotike Pratana. Okay, then how come he is in the picture?
Your Lordship, subsequently he has registered another FIR.
Hmm.
Can you please turn to the page number 26,
Hmm.
where he has requested that in the first FIR, the place of occurrence he has given was wrong. Actually, he has lost the mobile phone on Gauhati railway station, but mistakenly he has given that he has lost his mobile in Dabaka market.
Hmm.
How this kind of mistake can happen? This is not a
Harman
computer.
Nejে যোৱা
It's a
ইংৰাজী
written FIR, Your Lordship. He has lost his mobile at Gauhati railway station, but he has written at Dabaka market.
য'ত মই ঘটনাস্থল পল্টন বজাৰ গুৱাহাটী ঠাইত
He has written Dabaka market.
No, but then here you see, ইংৰাজী ইমান তাৰিখে হোজাই জিলা আৰক্ষী অধীক্ষৰ ওচৰত এখন এজাহাৰ দাখিল কৰোঁ য'ত মই ঘটনাস্থল পল্টন বজাৰ গুৱাহাটীৰ ঠাইত this is not correct, this is Dabaka market.
Exactly, I'm saying.
Kintu, no, not only this later part is different, but also the former part. Kintu ঘটনাস্থলী গুৱাহাটী ৰেলৱে ষ্টেচনৰ হোৱা মই কৰি গৈছিলো গতিকে মহোদয় দয়া কৰি এজাহাৰখনৰ বাবে he did not say that it was wrongly stated as Dabaka. It is actually railway station. He said wrongly stated as Polton Bazar.
Exactly, I'm saying.
So maybe he is referring to some other FIR.
Exactly, I'm saying, Your Lordship, in the first FIR, what he has said, that while he was shopping in the Dabaka Bazaar on that night, on particular
That
night.
was stolen.
Yes, his
Okay.
mobile was stolen.
Huh.
Okay, in the second FIR,
Huh.
which is at the page number 26,
Huh.
he has said that he has mistakenly, he has given that he has lost his mobile in Dabaka Bazaar.
No, mistakenly he had said that it was Polton Bazar. Huh?
No.
ওচৰত এখন দাখিল কৰোঁ য'ত মই ঘটনাস্থল পল্টন বজাৰ গুৱাহাটীৰ ঠাইত উল্লেখ নেকি?
Exactly, Your Lordship, I'm saying same.
What exactly? I don't know why you have not able to understand.
Just a minute, Your Lordship. In the
He
first
did not
FIR.
mention about Dabaka.
No, Your Lordship, in the first FIR, I'm reading it. I'm reading it for you. That Azarkari Khamar Dimul is on 23/3/2026 তাৰিখে ৰাতি প্ৰায় 10:30 মান বজাত মই ডবকা বজাৰত বজাৰ কৰি থকা অৱস্থাত মোৰ পকেটৰ পৰা মোবাইল ফোনটো হেৰাই যায়। মোৰ মোবাইল নাম্বাৰ so and so. What he said, he lost his mobile phone at Dabaka Bazar.
Then read the second one.
And the second one, what he has, the Khanmok Vidyalaya is যোৱা ইংৰাজী 30/3/26 তাৰিখে হোজাই জিলা অধীক্ষৰ ওচৰত এখন এজাহাৰ দাখিল কৰোঁ য'ত মই ঘটনাস্থলী পল্টন বজাৰ গুৱাহাটীৰ ঠাইত ডবকা লিখিছিলো।
Oh, Dabaka.
Yes, Your Lordship. He had to write the Polton Bazar Guwahati, but he has written Dabaka. Which is in Hojai district. Such a
But
big
then
distance.
it's okay. But how come you are in the picture?
One more thing, Your Lordship, my picture, how I am in this, the fraudulent transaction which he has said, on that fraudulent transaction only nearly 80,000 rupees was fraudulently came to my account. But
Came
it was,
to your account.
it came to my account, but I was not the person who has stolen the mobile phone and who has done this fraudulent transaction. It was some other miscreant. And in his
But
FIR,
fact remains the money is in your account.
money is in my account. I'm not denying that. But I have not stolen the mobile phone, and it is not me who has done the transaction. And in his FIR also, he has not specifically mentioned my name, that I have stolen his mobile phone and I have operated his
That
mobile
we
phone.
did not know. He said that I don't know anything. But money, he found it to be missing from his
Yes,
account.
that I am
And
accepting.
so the police had investigated and found that the money is in your account.
Yes.
Where is that? Anything
But
to?
how does it attracts your lordship 303 clause 2? Because I have not stolen the mobile phone. And I am accepting that fraudulent transaction has been taken place, but it's not me who has committed this crime. Someone else might have found the mobile phone.
303 will not only involve the stealing of the mobile phone, but also of the money. Money is in your account.
But for that, your lordship,
Yes, that.
your lordship, some more submissions are there, and there are many other anomalies in the first FIR. What he has said, your lordship, kindly.
It's okay, case diary. Then only we will come to know. Third, Mr. Are you Tapadar?
Yes, your lordship.
Learned counsel for the petitioners and Mr. B. Sharma, learned APP for the state. By this application, the petitioners have prayed for pre-arrest bail in connection with GRPS case number 104 of 2026, registered under section 303, within bracket 2 of BNS. Call for the case diary. List this matter on
Pokra, sir, lordship. 9th or 10th?
9th. 9th of September.
Lordship.
Yes. 10.
Hello, PRS bail application. FIR is at page 12, my lord.
Page 12.
Yes, my lord. Translated portion is page 12, vernacular is page 17. I read that, madam.
What is your name? Firdaus Ali. Hiddut Ali. So the charging sections were 61, 87, 64 those.
64, 127.
You are Hiddut Ali.
Yes, my lord. In this case, my lord, as per the FIR, labeled informant stated that on 2/7/2026.
Is she a minor? No, she haven't children. Okay. What is this other annexure to managing director?
It has been, my lord, annexed by the petitioner because on the said date of occurrence, my lord, he was even in Gauhati, my lord.
He wasn't?
In Gauhati, my lord.
Acha.
He submitted this representation because, my lord, his rice mill was suspended. So in this regard, my lord, he was in Gauhati, he suspended, he presented this petition, my lord, to this office, my lord. And moreover,
Okay.
my lord, on 2/7/2026, my lord, as per the allegation labeled in the FIR, my lord, the informant states that she was taken by the petitioner along with 2 other persons. She was taken to Gauhati. She stayed there for several days. That is almost 18 days, my lord. And she herself stated that she is having 3 children, my lord. She is having a family. And in these 18 days, my lord, there is no missing report, no FIR has been filed by her. Any of her
Mr.
SS Ahmed, my lord.
S.S. Ahmed, learned counsel for the petitioner, and Mr. S. Sharma, learned APP for the state. By this application, the petitioner has paid for bail in connection with Dhubri PS case number 284 of 2026, registered under section 61, subsection 2, 87, 64, subsection 1, 127, subsection 4, as well as 3, subsection 5 of BNS 2023. The FIR in connection with which the petitioner is apprehending arrest. Acha, this is pre-arrest bail bill likhiba, bottom line, prayed for pre-arrest bail. FIR in connection with which the petitioner is apprehending arrest was lodged on 22/7/2026 by the victim herself, right?
My lord.
By the victim herself. stating inter alia that the petitioner that she has three children and her husband had passed away, and that the petitioner is the neighbor, and that he has been harassing her continuously with the pretext of with the pretext that he would marry her. Full stop. She further alleged that in the night of 2/7/2026, two other person came to her house and asked her to answer the call of the petitioner, but that she refused to talk to the petitioner. However, she further alleged that the petitioner subsequently asked her to get into his vehicle, and that although she refused initially, but the petitioner forcefully made her board the vehicle and took her to a hotel in Gauhati. Full stop. She further alleged that she was with the petitioner in Gauhati for several days, and during those days she was subjected to sexual intercourse by the petitioner. She also stated that thereafter she was taken to Bengal and some work, okay, Bengal, and she was made to stay for the night. And that finally she was left at a particular place, and that the petitioner had fled from the said place, leaving her alone. Full stop. The learned counsel for the petitioner submits that the story narrated in the FIR was a concocted story, and to substantiate the same, the learned counsel further submits that on the day of occurrence, the petitioner was not at his house in Dhubri, but was in Gauhati in connection with some work. He further submits that the informant had voluntarily stayed with the petitioner at various places, and that there was no force applied upon the victim by the petitioner at any point of time. Mr. B. Sharma, learned APP for the state, submits that the allegation against the petitioner has been mentioned in so many words in the said FIR, to the effect that he not only forcefully made the victim deboard his vehicle, but also took her to several places and subjected her to sexual intercourse. Upon full stop. Upon consideration of the submissions made by the learned counsel, more so in view of the fact that the victim stayed with petitioner at so many places, but had never raised any alarm and told any person about the alleged physical intimacy committed by the petitioner upon her, this court deems it fit that the petitioner be enlarged on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the arresting authority under the following conditions. He will have to appear within 10 days from the date of the order, and rest of the condition. Petition is disposed of. I'll come back in 2 minutes. Mr. Nath, you have some matter?
Item number 51 and 52, the last item for hearing.
Papre. And those were mentioned. Oh,
Yeah.
no.
No, I think the other side wanted to update it, but the opposite party wants some time, I think, like,
Oh,
that's why. It's
is
the
it?
thinking, well, ultimately.
Acha, 50-51.
Yeah, last item also.
Oh, there was a mention done in the
They
morning.
wanted to update, but the opposite party wanted to file something.
But
So
then there is an allegation that you have not filed your objection.
that's what.
Okay, if they are there, I can take it up immediately after coming back.
It's all, but I don't see, don't.
I've seen him
It's
little
okay,
while
fine.
earlier. He was to. Oh, at 2. Maybe taken up hearing in post-lunch between 2 and 4.
No, it's all right.
Okay.
It's
There
all
was
right.
a, what? There was a,
Actually, in 1951,
Huh.
opposite party, they want to file something. They
Mm.
told me that, actually, she's my client, but I'm appearing in a 52, not in
Acha.
51.
Huh.
So he told me they want to file something, wants very short time, like 2 days.
Okay, okay.
That's what I was just thinking, my lord, ultimately.
Okay, there is a request made by the, I think, the council for the petitioner in person.
Yes, yes. So we can tell them
Okay.
also, like, if they allow for 2 days time, then
Uh-huh.
that's what.
Okay, then I'll take it up at 2. 2, I have a judgment to deliver in division bench. After
Yes,
5 minutes,
yes,
I'll come back.
Yes, yes.
2, 5 or 10, you can
Yes,
come.
my.
Okay, then we will. Okay. Ouch. Been seeing you for long.
After.
I hope you have having good health and everything is fine.
Fine.
We have a matter, please.
Item 17.
Okay, it will reach soon.
Yes, I am waiting.
I'll take it up before 1. 11. Huh.
Here in this case, my lord, on 17 February, my lord, 2026, my lord.
And last day, some last
Already, Lordship, charge
been
sheet,
instruction from the IO.
charge sheet has been submitted, Lordship, in the meantime.
Charge sheet it.
Charge sheet.
Wait
don't
one
know how-
second, I'll just read the last order. Seize cattle. Acha, ye Jimma of the cattle?
Yes, yes.
Oh,
8 numbers of cases, by.
8 number of cattle.
Yes. It is.
That
it
were
was
seized.
With the custody since 17th of February.
It's in the Goshala.
Now with the police, my lord. How now, where the police have kept, I don't know, my lord.
It will be kept in Goshala only.
Probably, my lord.
When was it seized?
17th February 2026.
Okay. Now the investigation is over and charge sheet is submitted. He is the accused.
That information I do not have, Lordship.
Acha, acha. So what happened? You have brought it in violation of the
They are
Cruelty.
That they were cruelty to an animal, my lord. In fact, there was nothing violating. In fact, as per the court's decision, my lord, the petitioner went to the police station and approached the IO and for submitting the original receipt. The IO even did not accept the receipt.
Show me.
Now,
If I may just place.
Where is the FIR?
Lordship, because the
Where is
Jimma was,
Seizure and the rejection order?
yes,
rejection order is at page 28, Lordship. During
29
this
is the
stage of,
So just show me the FIR first.
FIR, my lord, case 21.
21.
Yes.
Sikandar Mullah. Anyway, 8 number of cattle you cannot bring in one particular vehicle. You can bring only 6 number of cattle at the most, according to the Assam Cattle Preservation. So anyways, are you the driver? No, you are the owner of the cattle.
Yes, yes. My lord, the interesting part is that, my lord, till date, my lord, no anybody has came to the police and claiming their ownership.
Huh, okay, you are the owner, but where is that?
And
Receipt and all?
receipt. When it, my lord,
Bills or whatever?
13, one word, my lord.
$13.
Yes. Type of-
Seller's name is Ainul Haq, address so and so. Purchaser name is Sikandar Mullah, the petitioner.
Yes.
Where is the original?
These are the photocopy.
14.
Yes.
Yes, I mean the receipt. Annual hog, 2 pieces,
Oh,
two
same-
number of
same-
cattle.
Same, yes. Oh,
40,000, Sikandar Mullah.
is
They bought it when? 30th of January 26.
Yes.
And this 30th of January 26, and Caesar was made on 17th of February.
While they are bringing from.
Transported.
Yes, sir, transporting there.
Where was it purchased?
It was purchased at Alipurduar.
Alipurduar Jilla
Samuktula Hat.
Parikhad
Samuktula Hat.
Hat. Okay. How can you say that these are the cattle which were bought by these receipts?
Well, petitioners own cattle, well, they have seized, how petitioner cannot identify well.
31. This is also Alipurduar.
Yes, yes, all are Alipurduar. Same,
35,000.
they are purchased from the same, actually they are, well, actually they are businessmen.
2 pieces of cattle, 36,000.
Okay, if I may just make one submission. Lord.
Huh.
Lordship, the Jimma order is at page
Let's go to
20.
that.
Yes, that lordship was rejected at the stage of investigation because the IO has objected that it is required for investigation. Now lordship, since the charge sheet is filed, they can approach the concerned court lordship. That is,
Charge sheet is filed during pendency, right?
yes, on 31/7, recently.
Four number of cattle, the rejection order is at page 28.
Yes.
Four
Well,
number of
it-
cattle has
here-
been seized in connection.
Here, well, one interesting part, well, some cattle, there are 2 vehicles, well, in respect to another vehicle, the SDO has already released those cattle, those Jimma etc.
Here they have mentioned 4 number of
Yes,
cattle.
that 4 has already released. Now another, kindly come to page 29.
29 is the relevant portion.
Acha, let me read. Considering the IO is directed to give Jimma 4 number of cattle to the actual owner after proper verification and valid documentary proof, and the same along with execution of bond of rupees 1 lakh each cattle. Okay, this 4 has been given in custody
Yes,
to the same petitioner.
same.
Next page, lordship.
But in respect of 8,
That total 8 number of cattle has been seized in connection with this case. The IO has further submitted 8 now has not been ascertained. That the total 8 numbers of cattle has not been ascertained. The IO has further submitted a said cattle are required for further. And this is very bizarre. What happened?
yes, sir.
Total 8, they say, is seized in connection. 4 given. 4 is left. 4 are left.
No, lordship.
This is in respect of other cattle.
Other 8 in respect of the petitioner's cattle, 4 is different. 2 vehicles were there, lordship. Dekha diye.
So 8 on 1, 4 on 1.
Yes. Now, in respect of 4, Jimma petition number was 823 of 25, 26. And in respect of this instant 8, the Jimma petition number was 820.
So altogether there were 12 cattle.
Yes, yes. That same day incident, well, how SDM also.
But then total 8 numbers of cattle have been seized in connection with this case.
Yes, yes.
So that
Two-
4 number
there-
was a
there
different
are-
case.
Yes, there are also several PS case number. In respect of just 4 men. But here in this PS case, it's written as Osaka PS case number 38.
So cases are different in respect of 4 and 8. Because here also it is said that 4 numbers of cattle were seized in connection with this case.
It is different.
Hmm?
It is Caesar list also, it also 8 only.
Where is the Caesar?
Page 27.
47.
27.
27.
Description of.
8 number of seized cattle,
Yes, yes.
not 12.
Not good.
So this is what
With
case?
the Osaka PS case number 30.
This is DD entry. Where is?
DD 22, there also 22. Same DD entry.
Acha, you move it there. Because see, you have given receipt for 8 number of cattle. And you have also said that there were 4 other number of other cattle which were,
Yes, yes,
so there has to be 12.
yes, yes. Those eight, four I have already.
That I know. You don't have to repeat. 4 is already given in Jima. Now altogether there were 12 cattle.
Yes.
And the 4 was in respect of different case. Things
That
are
was-
not clear.
Now, there is SDGM and my lord, he had collated two same in the same case. Those PT case number. is different.
According to you, case number is same
Yes,
in respect of 8 and 4.
yes, yes.
But then see, it is said that, so you move it before the trial court,
Hmm.
right?
It will be better.
Better. Then you will know. You are withdrawing?
Yes.
Okay. Move it before the trial court. Heard Mr. S. Hawk, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. Mr. B. Sharma submits that the instant case, that the police has completed the investigation of the instant case, that is Gosaigaon PS case number 38 of 2026, and had submitted charge sheet. White charge sheet number
139 dated 31/07/26.
2907.
31.
Oh, 310726. So as such, the learned counsel appearing for the petitioner submits that he will move the appropriate application before the concerned court. Accordingly, the petition is closed. Yes, Ms. So.
42 application, Lordship. Impugned order, Lordship would be pleased to find at page 33, Lordship.
What have you
Yeah,
challenged? Just a
rejecting-
second.
Rejecting the prayer for Jimma of vehicle as well as 200 bags of rice, Lordship.
Achha.
Now, while rejecting the trial court, observed that since the confiscation proceeding is pending, so the Jimma has
As
been
far as
rejected.
rice is concerned.
Rice and vehicle.
But
both.
confiscation can be done before the trial is over.
No, that is not this code. Earlier, it was a bar under 6E of the essential commodities there. That bar, but this honorable court as well as Apex court has lifted that bar. Various judgment has been passed to that effect, saying that pending confiscation proceeding is not barred to entertain Jimma application. While panel provision are also there. In my case, Lordship, in the given case, Lordship, here along with 7 of ECF, this other sections of the DNS also there, 61(2).
So where is the FIR here?
Yes, FIR is Lordship.
Hey, Amanda.
FIR is at page 23.
Essential
Lord.
commodities account.
Before that, just let me place the fact in brief, Lordship.
No, I'll come to know about the
Lord-
fact. Just
Lordship.
show me the FIR if you have annexed.
Yes, Lordship, at page 23. May I read, Lordship?
Yes.
With reference to subject cited above, I have the honor to report that today so-and-so at about 9:24 a.m., a source impute was received by the officer in charge, Worcester Police Station, regarding the illegal transportation of PDS rice from Borpeta to Meghalaya in a truck bearing registration number this. Accordingly, a general diary entry was made by Worcester PS case number so-and-so. I was directed to take necessary legal action. In compliance with the direction, I, along with the staff, proceeded to Lalmati and conducted NACA checking. During checking, the aforesaid truck was intercepted at Lalmati, so-and-so outlet at about 3:20 p.m. Upon inspection, 200 bags of PDS rice were found loaded in vehicle. The driver failed to produce any valid document relating to the lawful possession, sale, purchase, or transportation of the said rice. The driver was apprehended on the spot, identified as so-and-so. The truck bearing registration number so-and-so, along with 200 bags of suspected PDS rice,
Okay, yes.
believed to be government property, was seized in accordance with law, one mobile so-and-so. So
And
this
this truck is
so
also-
my contention is, Lordship, these are PDS rice. These are PDS rice, not disputed. These I have availed through e-auction, Lordship. Lordship would be pleased to come to page 25, Lordship. There are I have participated in e-auction process, Lordship,
Hmm.
which was held at Bongaigaon under Bongaigaon Food Corporation India Limited. And there are two challenge that release order I have annexed to this application, Lordship.
From
dated
where do I
24.
make out?
Uh, That were page 25, Lordship. One is
25?
at page 25 and the other is at page 20.
Please deliver
26.
to Ershad. What is it?
Irshad. Mama, the petitioner number, it was referred to
Sahidul.
the, petitioner
Sahidul
number,
is-
yes.
But you have
He's
not
the-
mentioned that he is the proprietor of this Ershad Traders.
Lordship, probably I have,
Okay,
yes.
please deliver to
No,
Messrs.
that
Ershad.
I have mentioned, Lordship.
Petitioner number 2 is also connected with Ershad.
Petitioner number 2 is the owner of the truck, Lordship.
Oh, he is the owner of the truck.
Now both are on bail, Lordship.
Huh?
Now both are on bail. This honorable court has granted them PRS. Well, thereafter they have produced the documents also before
It's
the.
okay, they are on bail.
They are
Petitioner
on
number
bail.
1 is the proprietor of the Ershad.
Asia Traders.
So he wants the rice back
Rise back, Lordship.
and he
Now,
wants the truck back.
and the other one wants the track back.
Huh.
Now contention of
So
the
deliver to,
petitioner.
but 1 second. Deliver to Messrs. Ershad Traders near Government Model Degree School. Quantity of below mentioned commodity against the cost deposited by him in accordance with tender terms and conditions. So this is how many bags? 200 bags were
No,
recovered, right?
total Lordship, there are two each challan is there.
So how
Lordship.
can you,
Total 13 metric ton and in another one at page 26, Lordship.
here 22 metric ton.
Here 22 metric ton and 13 metric ton. Total 35 metric ton he has purchased.
Where
Two
is the
different-
13 metric ton?
The first one, page 25.
Page 25.
Page 25 is the first one. That the release order ends with last two digit is 56 and release order ends with last two digit ends with 53. That is at page 26. There are two each alone. On the same date, he has
Where is it?
participated-
Where is it? Each alarm? Where have you shown?
This release order. One is at page 25.
25, where is that challan?
That release order number.
Where is
Lordship,
release order?
if that Lordship would be pleased to find that first column, Lordship.
Commodity and
column.
variety.
That release order, manager, below manager column. The
Before-
first, in the
Ah.
left-hand side, below
So,
manager
acha,
column.
okay, release order is
Release
this.
order number, these are the number, release order number, so and so.
Okay.
So and ends with 56, dated 24/4/2026.
But,
This is of 13 metric ton. And Lordship, the other one is release order number, page 26. This is 22 metric ton. Total, he
so
has,
in paragraph 2, you have stated he is the owner of Asia Traders.
yes.
How can be owner? He will be proprietor. It is not registered firm.
Yes, Lordship, proprietary. Maybe debate. That
The
would be-
aforesaid business establishment is a sole proprietorship firm and registered.
Yes,
So instead of saying owner, he should be a proprietor.
yes, Lordship. And he's also having GST and all. I have an annex that also. And how these rices were transported to his go down at Nij
What is
Bagbor.
page 27? This is FCI?
This is where FCI that
Truck ship.
that truck. It was loading permission of those truck number while receiving,
Acha,
while
this truck-
purchasing,
this
while
truck-
purchasing,
Huh,
this-
while loading.
while purchasing.
Acha,
Because
this,
this petitioner number 1, he purchased this source of the rices, he purchased from the e-auction.
but then the truck number doesn't tally with the
No,
truck.
Lordship, that was the initial. At the time of purchase from the Bongaigaon to Nij Bagbor, these are the truck. Was involved.
Knees backboard.
Nij Bagbor to his own go down. Thereafter, Lordship, he sent two consignment. One at the time which has been intercepted, and other I have annexed the order that was also intercepted. And that order, Lordship, I have which the learned trial court while rejecting has referred the number also. May I
What is
take your
page
Lordship to the rejection order once, Lordship?
Acha, what is that? Page 29? Consignee is Asia Traders. And then depot name is Horbo.
Yes, page 29. These are the truck sheets. These are the delivery at the time of purchasing, Lordship. This arrangement was made. These are the truck were involved.
So from purchase,
The
place of
purchase.
purchasing
And
to-
thereafter, Lordship, page 31 is the invoice through which petitioner was selling. Page 31. That on the day of interception, he was with this challan, he was selling those rice bags.
Consignee is Aman store.
Aman store, Lordship, at Gauhati, Lordship, page 31, Lordship. Page 31, Isha Traders,
He sold the rice to this Aman
then
store.
this Aman store.
So
It
before
was
he
on
could sell
way,
it.
on way to transit, but on the way it was intercepted, Lordship.
So before
Bosishta.
reaching Guwahati, it was intercepted.
It was
It was intercepted where?
Bosishta, near Bosishta. Bosishta police station.
But it is said that it was going towards Meghalaya.
No, Lordship.
In
That
the
is
FIR,
their
you
version,
see-
Lordship. That is their version. They projected this way.
Where was the FIR?
They projected that is their version. But the fact remains these rice bags petitioner purchased through e-auction, and he made two challans, one earlier sold, and that was also
Where is the
intercepted.
FIR? Where is the? I forgot the page. What is the number?
Page
23.
Page
23.
23. Lordship.
Three.
Page 23.
See, here it is said from Borpeta to Meghalaya.
Yes.
So
Just to make out a case, this was this Lordship. It was challan was readily available along with the vehicle, Lordship. It was their Lordship. And my vehicle number also their Lordship.
where?
At page 31, motor vehicle number at the fifth column
Hmm.
from the right hand side, Lordship.
0792.
Yes, this is the vehicle number, Lordship. And Isha Traders, that is proprietor of from Nij Bagbor,
This Aman
Stop.
store is in
Guwahati,
Ganeshguri.
Ganeshguri, Guwahati, on the way to transit, Lordship.
Okay,
And
show me the
Bosishta
rejection
it
order.
was, intercepted.
Show me the rejection order.
Rejection order is that page, Lordship,
35.
33, Lordship.
What is this 35 order?
Not 33, Lordship. That was I have referred another, which learned trial court has stated. May I take your Lordship to that, page 33?
This is in respect of another case.
That is,
No, not required.
not
What about this case?
this case, page 33, Lordship.
35.
Page 33.
35 is what? Another case.
That refers, that the trial magistrate has referred another case because they have referred that other case also there. In fact, other case also there where Jimma has been granted out
In
of
respect of the petitioner.
in respect of the.
Okay, I'll read this way.
Yes, Lordship. May I read, Lordship? This is 29/7/2026, so and so. Today is the date fixed for Jimma report. Report called for so and so in respect of vehicle bearing number. So the vehicle number has been mentioned. 200 bags of rice is received. Seen report wherein IO stated that seized vehicle is very much material for further investigation of the case. The ownership of the involvement of the vehicle in commission of the offense are yet to be conclusively established. The registered owner of the vehicle is required for interrogation and examination, and his role in the offense is under investigation. Further, Lordship, further the confiscation proceeding regarding the seized PDS rice has already been initiated before the competent authority is pending presently. During investigation, prima facie evidence has emerged indicating the vehicle was repeatedly used for illegal transportation of sale of PDS rice for wrongful gain. It has also been revealed that the owner was previously involved in a similar offense registered under Rongya PS case 198/26. That is why I have annexed that order of that case, Lordship, indicating habitual involvement
I've
in
gone
such
through it.
illegal activities.
I've gone through it.
Releasing the vehicle and rice in Jimma of the petitioner will hamper the investigation. Learned so and so prayed not for grant of Jimma at this stage. Had both sides peruse the case record and report. It appears from the report that aforesaid seized rice and vehicle are
It's
required
okay,
for
Miss Som.
further.
It's okay, Miss Som. What do you say, Mr. Sharma?
Lordship, before that, just my, but Sundar Bhai Ambala taking into account.
So
of
you
the
said
fact-
that during the confiscation proceeding, Jimma can be given. Where is the
Jim can
judgment?
make that judgment.
You
not
have
but-
brought- that is a
but
question.
Lordship has already dealt with that. Lordship has
No, I
already.
forgot,
named
I
it.
don't remember.
Yes, Lordship.
Then you have to show
one of
the,
the
yes,
justice
Mr. Sharma.
High Pitch order was there. That,
Okay.
that was the first order in the revisional court, Lordship.
Okay, okay.
The report as well as the case diary may be called for Lordship, and then the matter may be decided.
May I pray that short date may be.
It's
fixed,
okay, but
Lordship?
then what do you say on this confiscation proceeding? You have the judgment?
No, Lord.
But
Mr.
Lordship,
Bosha, Mr. Borua, do you have? That during confiscation proceeding, rice can be given in Jimma.
it can, Lordship. No, no, no.
After trial, actually.
After trial.
But then here, what is the provision of confiscation under the essential commodities?
That earlier Lordship, before passing of judgment Lordship by this Honorable Court and Apex Court, that was under 6C, it was bar Lordship. Definitely it was bar under 7 of EC Act. 6C. 6C was
6C.
particular, 6C of that section.
6C is appeal.
I'm not holding that book right. this moment.
6C is appeal.
6C of the 6C, before that, it was, on the next day I will, if your Lordship is calling for the report from the IO as he paid for, so on that day I'll.
No,
take the
yes, it is,
judgment also.
6 is confiscation.
Yes, that was bar, earlier bar, but this Honorable Court has lifted that bar, passing the number of judgment. Even I have in one my case.
One
Lordship.
second, let me read this. May confiscate, it is there in section 6, but
May I?
were you given notice for confiscation?
No notice, Lordship. Lordship, may I pray? I'll place that. I'll satisfy to that effect whether the criminal court is empowered to deal with that subject or not. I'll satisfy because even in one of my case, order has been passed, Lordship.
It's okay, ma'am. Since you have not got the notice, the confiscation proceeding cannot start.
Yes, Lordship.
So let me, as far as the truck is concerned, what do you say? This,
Both Lordship, both Lordship. I have investigated
because
them out.
He may be called for and a report may be called for.
not required. You see this, only Jimma during the trial, she will have to produce, she will not seal the rice.
Yes.
And she cannot dispose of the seized rice bags without permission. So she'll have to take permission
Yes.
and we'll have to produce the rice bags before the court as and when directed.
Lordship.
But Lordship,
Right, those conditions will be there.
yes,
Yes,
But
Lordship.
truck, what she had shown from the the challan or whatever, that truck number is same. She had taken those
but Lordship, in the
to
rejection,
Ershad.
in the rejection order, Lordship, the IO has given a report. And in that report, it was cited, Lordship, that there are reasons for further investigation.
Now
So
they,
regarding
huh.
the rice, Lordship, nothing is there, but regarding the truck, Lordship, at least Lordship will peruse the stage of investigation because there, the truck, Lordship, it is
No,
also
see,
stated that.
that is not the mandate.
Lordship,
The Supreme Court has said in Ambala that as soon as possible, magistrate has to
Yes,
keep
yes,
the
yes.
Jimma.
Yes,
So there it is not said that you see
Yes.
whether it is required for investigation, because that will be used for investigation, no doubt.
Yes.
But it should not be kept. When was it seized? February.
February Lordship.
February 26. So
With
now
His Lordship.
almost 5-6 months have gone.
6 months Lordship.
Okay, with conditions, I'll give it.
Lordship.
Heard Miss T. Soam, learned counsel for the petitioners, and Mr. B. Sharma, learned APP for the state. By this application, the petitioners have prayed for quashing of the impugned order dated 29/7/2026, passed by the learned judicial magistrate, first class, Kamrup, M, Gauhati, in Bashishta PS case number 262 of 2026, registered under section 61 within bracket 2/305 within bracket small e /317 within bracket 2 of BNS 2023, read with section 7 of the Essential Commodities Act. The present petition, the present petition is filed by two petitioners, namely Sahidul Islam and Rukuddin, Rukuddin, Rukuddin Rahman, full stop. It is stated, it be stated that petitioner number 1 has claimed for custody of the truck, right? Of the rice.
Petition
Rice. Has claimed the custody of the rice which was seized by the police in connection with the Borpeta PS case number. No, not Borpeta, right? Boshishta PS case number 262 of 2026. And petitioner number 2 has claimed for custody of the truck bearing registration number AS01 KC 0792, which was also seized in connection with the aforesaid case. Full stop. The case in connection with which the rice bags and the truck was seized was lodged on 14/7/2026, wherein the police personnel had stated that on a source information that rice are being transported from Meghalaya from Borpeta to Meghalaya on a truck, Naka checking was conducted and the truck was intercepted at Lalmati, Beharbari at about 3:20 p.m. on 14/7/2026. Full stop. The informant further stated that upon inspection, 200 bags of PDS rice was found loaded in the said vehicle. Full stop. The driver of the said vehicle was apprehended and documents were asked from him, but he could not produce any valid documents with regard to the rice. Full stop. The police after seizing the rice as well as the truck, took the driver as well as the seized articles to Boshishta police station. And after conducting a preliminary inquiry, it was found out that the driver, in connivance with other associates, was illegally transporting PDS rice for his unlawful gain, causing wrongful loss to the government. Full stop. The learned counsel for the petitioners submits that the petitioner number 1 is the proprietor of Ershad Traders, SHAD of Airshad Traders, and by referring to the documents had stated that the said rice, that is PDS rice, was purchased by Airshad Traders on 24/4/2026 by way of two release orders, right? By way of two release orders. Full stop. One release order showed that the said proprietorship firm purchased 13 metric tons of rice, and by other release order, it is shown that the said proprietorship firm purchased 22 metric tons of PDS rice. Full stop. The Learned Counsel has also placed the truck sheet, TRUCK, RCHIT, truck sheet, by which it is demonstrated that the rice were taken from Bongaigaon, what?
Yes.
To Nice Bagbor. Before that, what is this?
Niche Bagbor.
Page number 27. Before Nice Bagbor, what is this? Submits that the rice was taken from the place of purchase
Niche Bagbor.
to Nice Bagbor. Nice, NIZ-BAGHBAR. Niche Bagbor. And thereafter, the said PDS rice was transported to the purchaser at Ganeshguri, and to substantiate her claim, she has placed the bill of supply wherein it is demonstrated that Airshad Traders had sold the rice 12 metric tons, right?
Yes. Lord.
And the rice to
Aman.
one Aman store, Messrs. Aman store, located at Ganeshguri, Gauhati. Full stop. The Learned Counsel submits that when the truck was in transit, the said rice was seized, but the rice were in fact PDS rice, which was properly purchased and was sold to PDS rice. Can it be sold
Yes, Lordship. He is
to
purchased
the
not
fair
from
price
Yes.
shops?
Not fair price, any other. Now we
Sold to Aman store in Guwahati. Full stop. With regard to the truck, the Learned Counsel had showed that the said PDS rice was carried in the said truck bearing registration number AS01 KC 0792, and the same is reflected in the bill of supply. Full stop. As such, the Learned Counsel has prayed that custody of both the truck and the rice be given to petitioner number 2 and petitioner number 1 respectively. Full stop. Mr. B. Sharma, Learned APP, however, submits that in the rejection order by the Judicial Magistrate First Class Kamrup M, it was stated that the petitioner had also on an earlier occasion had transported rice, PDS rice, and cases were instituted against him. He also submits that the confiscation proceeding is on with regard to the seized rice, and as such, the rice cannot be given in custody to the petitioner number 1. Full stop. He also submits that in the said order dated 29/7/2026, it is also reflected that the ownership of the vehicle is not established and that it was also required for a further investigation. Upon consideration of the submissions made by the Learned Counsel, this court finds as follows. It is a settled position of law that articles or vehicle seized in connection with any criminal offense should be given in custody to the owner or from whom it is seized or to the insurance company under which it is insured as soon as possible by the magistrate. However, the apex court has also held that before giving custody of the said articles or the vehicle, proper panchnama, comma, guarantee, bank guarantee, comma, guarantee that the petitioner would produce it during the trial, comma, the photographs and other procedures should be followed. In the instant case, it is seen that that by release orders, the petitioner had bought the rice from the Food Corporation of India and was transporting the same on the truck that was seized and sold it to a concern in Gauhati. The bill of supply annexed with the instant petition also substantiates the fact. Acha, where are the registration certificate of the truck that you are the owner? Rice, okay. Truck? Have you annexed?
Yes, Lordship, page 20.
Further, it is also seen that petitioner number 22,
Number 2.
that petitioner number 2, namely Rukuddin, this is Asuruddin, this is driving license. Where is that registration certificate of the truck? Registration certificate, page 19. No, this is Ershad.
It's wrongly kept by the clerk, Lordship. Should be driver's license has been accessed.
If you have the correct paper, give me. Annexure 2 is the registration certificate, but then it is not, it is one driving license was.
Yes, Lordship.
So,
I'll place it, Lordship. 510.
no, I'll tell the police to verify and,
Yes.
কি করলাম?
It is to see that.
Further, as far as the ownership of the truck is concerned, it is the pleaded case of the petitioner. Number 2. No. Petitioner number 2, truck is 2, right? Petitioner number 2, that he is the owner of the truck bearing registration number AS01KC0792. Chassis number MB, capital MB, 1, capital A, 2, capital GCD. I say to Lolo number 2. Page my heri koi do. Ma mark koi aso. Chassis number as well as engine number, and maker's name di diba, color di diba. Ma hini mark koi diso. Etu chassis number e gute hin di diba. Is the owner of so and so. My green mark koi diso. Page number 3. So and so. As such, this court in the light of the mandate held by the Honorable Supreme Court, directs the investigating officer to verify on the aspect of ownership of the truck, and if it is found that the petitioner number 2 is the owner of the said truck, the truck be given in custody to the said petitioner number 2, namely Rukuddin Rahman. Rukuddin Rahman. The IO is further directed to comply with other conditions such as taking photographs, taking bank guarantee, as well as drawing up proper panchnama and the further requirements as provided under the law. Full stop. As far as the bags of rice are concerned, it is noticed that even if it is stated that confiscation proceedings are on, but then it is also seen that notice to the owner of the said rice as per section Section 6B of the Essential Commodities Act 1955 was not given, and accordingly the notification will not, the confiscation will not be proper. In view of the same, the rice being shown to be owned by petitioner number 1 by way of release order and bills of supply, the same be given in custody to the petitioner number 1 during the pendency of the case. Full stop. The IO is further directed to comply with all the conditions narrated above while before giving custody of the rice to the petitioner number 1. Full stop. With this direction, the petition is disposed of.
Fix a bond lordship so that otherwise it.
Truck.
For the truck and rice, a bond of.
Truck is a what? This is a trailer.
Bond of-
What trailer truck or what?
This is.
Ashok Leland.
Yes, lordship.
So
Bond of rupees, they will furnish a bond lordship.
bank guarantee of.
Bank guarantee lordship would be
Bond.
difficult. Bond lordship, already they have suffered huge loss.
Acha, tate comma diba appropriate bond.
Bond,
Appropriate bond with a reasonable amount of a reasonable amount.
Bank guarantee will again cause inconvenience to the hardship to the petitioner lordship. They have suffered lot.
Okay, you go if some more bank guarantee is given, come to me, come to this court. But bank guarantee is given, has to be, depending on the value of the vehicle.
Fix up a bond amount.
Bond of a reasonable amount, so I have said they will not harp on the petition is disposed.
Very much grateful, Lord. Highly grateful.
Sorry, my lord. Number 34, my lord. Already charges have been laid, my lord. And they are on the interim bail, my lord.
Acha.
34 item number.
34.
34, my lord.
You are on interim bail, charge sheet is late.
Charge sheet.
So, okay, we will extend the interim period and you move it before.
Yes.
So 34 likha, huh? Mr. SK, yes, heard Mr. SK Jain, learned counsel for the petitioner, and Mr. B Sharma, learned APP for the state. Yeah, na? File to 34.
34.
Mr. B Sharma, learned APP for the state, submits that the case that the charge sheet has been submitted in the instant case by charge sheet number
75 dated 29/6/26.
75 dated 29/6/2026. As such, the learned counsel appearing for the petitioner submits that he be allowed to move a appropriate application before the concerned court. However, it is also seen that the petitioner was enlarged on interim pre-arrest bail, right?
Right, ma'am.
Wait, where is that order? Interim pre-arrest bail by order dated 7/4/2026. And as such, the said order dated 7/4/20, the said interim bail protection is extended by another 15 days so as to enable the petitioner to move the appropriate application during the said period,
Considering accordance.
which will be considered as per law. Petition is closed.
One item 27.
Hmm.
Second one, I have some difficulty. Man. Can you count already?
27,
Prohibition is
criminal appeal, 27.
27.
Mr. H. Ali appears.
And there it is.
Acha. Okay, 27, otherwise criminal appeal for admission. I'll admit it, call for the records. You need not be here. No adverse order. I'll admit it, call for the records. And is it under POCSO? Is it under POCSO?
No, this is under NIA complaint.
Okay, okay, I'll admit it, call, and then notice issued to the other party. Okay, notice issue, I'll do it. Okay. And Mr. Gogoi, you had which matter, 17?
17. Very small matter, my lord, was seeing,
Ah,
but here this FIR.
and you accept?
17.
17.
FIR is a long one, my lord, 88 pages of FIR. Here,
So you want quashing of the FIR and
passing of the
subsequent?
FIR as well as my lord, charge sheet submitted, my lord, charge sheet also. Trial is going on, my lord, initial stage, evidence not started, my lord. Sections here, my lord, only 354 and section 6 of Assam, hailing.
But then I'll have to go through the FIR and see whether ingredients are there or not.
Yes, yes.
Or today is the first day.
This day. But here, case registered under 10 sections.
So let me issue notice to the informant.
Under two sections.
Let the notice go to the district number two.
Then scan copy of the record may be called from.
Is it required?
This
Yeah,
is-
I'll see the FIR. If
This-
it makes
this-
out a cognizable offense, no quashing.
So this is a cognizable offense, my lord,
Then
because my lord,
what quashing?
section 7 of the, my lord, this act, my lord.
Ah.
Assam Healing,
Six.
no, Assam Healing Prevention of Evil Practice Act 2024, my lord, as per section
Evil
17.
Practices Act.
Yes, as
Some-
per section 7.
What do you say?
Provision is 1 year punishment, my.
No, my
That's
submission is, my lord, as per section 7, my lord, it is cognizable, my lord.
Ah.
That is my submission.
Discloses a cognizable offense. How can that be quashed?
No, here, my lord, this section, my lord, 354, that is a provision only 1 year and fine. Another section, my lord, that is section 6 of the Assam hailing practices 24, that is 1 year may extend to 3 years. That is the, my lord, punishment.
But okay, see the definition of cognizable offense?
Yeah, that is what I understood.
Huh.
That very, my lord, I think this is only these two sections.
Whatever is provided in the chart, right? What is the definition of cognizable? 2 years and above? No,
Yes, no, yes, my lord.
huh?
Cognizable offense, my lord, the police can, my lord, arrest without a warrant, my lord. That is a cognizable offense.
Huh. Yes. Then 354 is a cognizable offense.
354, my lord, the act caused by inducing person to believe that he will be rendered an object to
354
divine
BNS.
BNS, my lord.
BNS.
Not
It is
BNS.
1 year and fine, my lord.
Acha, wait, I'll see whether 354 is a, this is non-cog. 354. Act
354
caused by
BNS.
inducing a person to believe that he will be rendered an object of divine displeasure. Okay, so this is non-cog.
This is not cognizable, but my lord, section 6 of the, my lord, Assam Healing Prevention of Evil Practice Act 2024.
That is cog.
That is
It is
cognizable.
also 1 year, my lord, may extend to 3 only.
No, doesn't matter 1 year. If it is a cognizable offense, then
Yes,
FIR
yes,
is
yes,
maintainable.
yes.
So you know much more than me. So if it reveals a cognizable offense, how can that be quashed?
Some provisions, I have shown, my lord.
Then
my
okay,
lord,
today let the notice be issued or what?
Notice
if-
may be issued.
Who is this phone number two?
Respond number 2, my lord, that's the informant, my lord.
Informant.
Yes.
That was not required. Yes, Mr. Borua?
Yeah, but notice may be issued to him.
Notice may be issued, I have no objection, my lord. Till returnable that, my lord, that may be statement.
No, that I have objection, my lord, because charges have already been framed, my lord, before a trial court. Lordship may peruse page number
Charges
108. Yes, charges framed, my lord.
Started.
Yes, trial is started.
Trial started.
Let the SKN be called for, my lord. We require, my lordship, we can consider this play on the next day, my lord, while the LCR or TCR will come, my lord. Scan TCR, my lord.
That will not serve any purpose. Why?
Question is that, my lord, without perusing, my lord, what is the materials, my lord? there is only the search sheet, my lord. Because a TCR, my lord, it will reflect everything, my lord.
Search sheet, my lord, search sheet submitted for 10 sections, on 10 sections. But
it cannot
search
fit.
claim only on 2 sections.
Yes, my lord, that
It
is that.
shows that, my lord, some wrong assessment taken by the IO, my lord.
Doesn't matter. Charge is framed under two sections.
Yes, yes.
Okay, after hearing both the parties, they've decided, but that will not be fatal. Okay, you wait. In the second half, I can take it up and what? Close the matter or dispose of the matter.
No, my humble submission, my lord, that the notice be go, my lord, and the scan TCR may be called for, my lord. In a next date, my lord, lordship can, my lord, consider this.
For quashing of the FIR and the charge sheet, scan copy of the TCR is not required. I'll see the contents. Right.
Your lordship, please see that FIR of 88 pages, my lord. In my long 30.
I'll read the first page and the last page.
88 pages FIR.
This is not an FIR, this is encyclopedia.
Maybe, my lord, but.
Okay. Okay, second half, we will see what can be done. I didn't want to keep you waiting till the second half, so I took it up. But if I can dispose it of today, what?
No, my lord, regarding disposing of, my lord, without the TCR, my lord, I have objection, my lord. Because charges have already been.
His objection.
The charges have already been framed, my lord. Charges have.
Supreme Court says, if an FIR and the connecting documents shows that no case is made out, then quash. Otherwise, if a case
Lordship
is
is
made out,
absolutely correct, my
don't
lord. But
quash.
this matter was also be considered by the trial court, my lord, while framing charge, my lord. Without trial court, without, my lord, considering this aspect,
No,
frame charge, my lord.
frame charge under police papers.
Police
And
papers,
on-
as well as the, my lord, contents of the FIR, as well as the other materials collected by the IO, my lord.
Ah,
Because
look,
search, he has challenged the FIR, my lord, then search it, then framing of search, everything he has challenged, my lord.
Calling the scan copy. Okay, heard
This is, my
Mr.
lord, any sort that.
Heard Mr. Gogoi, B. Gogoi, learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state. By this application, the petitioner has prayed for quashing of the FIR as well as the charge sheet and subsequent proceedings. Full stop. Issue notice. Petitioner to take steps for service of notice upon respondent number 2 by speed post with AD or by usual process. Mr. Borua submits that in order to see the materials that were considered by the trial court while framing charges, the scanned copy of the trial court records be called for. Trial court records be called for. Accordingly, call for the scanned copy of the trial court records. List this matter after 2 weeks on a date to be fixed by the resident. Okay? Noted?
Maybe speak.
No, after only. Okay, on the interim to be considered on the next date.
Next item, my lord, item 30, only revision petition lordship against the order of
13.
lordship. This stage lordship.
Oh, DB में जाना है. हाँ, 13. You are not there in the second half.
Lordship, I have.
Acha, 13. What is to be done in 13?
Lordship, at this stage, let a notice may go and further proceeding may be stayed. It was.
No, further proceedings stay, then I'll have to see.
Lordship.
You tell your junior to be here.
Lordship, next, second half, lordship.
My lord, this
Second-
is a DV case, my lord.
DV case, lordship.
But the presence of the opposite party will be necessary, my lord.
Only notice.
No, lordship, 1 lakh rupees fine was imposed, lordship.
Okay,
Without
I'll see it in the second half.
That part, lordship, to be stayed,
Achha,
because otherwise.
Okay, I'll see it in the second. Yes. You are saying which one, who did not file affidavit? You said the opposite party had not filed affidavit.
Respondent
in spite
number,
of Many.
respondent number 2, Milord.
Respondent number 2.
In
Item 50.
Yes, Milord.
So, who is appearing for? Respondent number 2, Mr. S. Rahman and, Mr. A. Mishra.
No, Your Honor, I am Upendra Pandey, Your Honor. I am
Acha.
respondent number 2, Your Honor.
Okay.
I am on behalf of Pooja Upadhyay, Your Honor.
So, you have not,
We need to file a counter affidavit, Your Honor, so kindly give me a short date, Your Honor.
you have taken time on many occasions, I'm told.
Yes, Your Honor.
Yes, Milord.
So we need to be 2 days only, Your Honor.
Last occasion, you were not there.
Yes.
Milord, last occasion conducting counsel was Mr. A. Misra.
Hmm.
And last to last was also Mr. A. Misra. Both the time he not appeared before the court.
Acha, what is the matter about Mr. Nath? What is the matter about?
Basically, my lord, it's about love affairs in a mobile.
Oh, acha.
Story starts from there.
Huh.
Somehow they got friendship in the
Hmm.
mobile, Facebook.
Hmm.
It turned into a good friendship.
Hmm.
Then the girl came from Itanagar to Gauhati. I think from this side, I think who is the person? You are the person.
You are
Two
the one.
brothers.
Yes.
One of the, I don't know because first time I'm seeing them. So he came from UP.
Hmm.
They stayed in a hotel. And the allegation is, Lordship, understand from the,
Hmm.
that's the allegation. The charge sheet was filed.
Thereafter, she lodged the FIR.
She lost the FIR,
Saying,
76, and
forcible.
cheating, all this, everything it came. So probably I do not like, he has come for quashing of that one.
Yes.
Okay, number
Ah,
one.
Quashing of the FIR.
Yes.
Yes, my lord.
As well as the charge sheet and
Yes,
subsequent.
entire proceeding.
Okay, trial.
Trial,
Sure.
my lord, is at pre-trial stage. Discharge application has been filed after the submission of charge sheet, but
Framing of charge is not done.
yes, my lord.
Done or not?
No,
Not
no,
done.
no framing. of
Deferred
charge.
application is filed.
Yes, my lord, it is pending before the trial court.
Acha.
So
Okay.
far the second one is done
Hmm.
because this
51.
respondent about second 52.
51.
No, 51 is his one. In 52 also.
52 is not connected.
50 or 50?
50.
Or 50, 51. 50 is there.
Huh.
51 is opposite party is, I think, he is the opposite party.
Ah.
Since last 1.5 year, we are trying to serve them copy by registered board, by email, everything we failed. Now,
Acha.
since they are appearing in court today, my lord, in
Ah.
front of your lordships, my lord, I am giving them the copy.
Uh-huh.
Let them take the
Yes.
copy along with the signature.
Yes.
Then what purpose will be served? Because they are avoiding probably.
Hmm.
Email, register post, everything still 1 year we try, we cannot serve the copy. Today they are
Acha,
here, my
so
lord.
51 is for what? Again, quashing.
My lord, there what happened? They
Then
filed.
Pooja Upadhyay.
Yes. Another FIR was filed by them.
Oh.
Their final report was filed.
Hmm.
Against final report, they filed one petition.
Hmm.
After filing that petition,
Protest
they-
petition.
protest petition.
Hmm.
But your lordship will see there is a technique tricks here.
Hmm.
One petition protest was filed. Subsequent dates, he was absent along with steps.
Hmm.
After a few days, he filed another protest petition.
Oh.
So lordship knows about the law.
Hmm.
There,
Hmm.
what happens unless disposed that one.
Yes.
On that issue, the second petition we have
Oh.
challenged this one now.
Okay.
Because lordship is aware, my lord, Supreme Court, from the Gauhati High Court, one matter went to Supreme Court.
Hmm.
This matter is from Silchar.
Hmm.
Their second petition was filed. It was upheld by honorable of this court, my lord.
Hmm.
It went to Supreme Court. Supreme Court, no. In that judgment, so many references has been given.
Acha.
And it says, no, once it is disposed of or somehow, my lord, if it's not there, you cannot file the second one now. So this is the law. I'll just please your lordship, my lord.
Okay.
That's all.
ये कहना है इसमें कि थोड़ा सा मिसलीड हो रहा है कोर्ट यहाँ पे। हुआ क्या मैडम कि मेरे भाई के ऊपर एक मैरिड वुमन है, उन्होंने एक हनी ट्रैप करके रेप का केस किया। उसमें उन्होंने जो डेट ऑफ इंसिडेंट डाला वो मैच नहीं कर रहा था एफआईआर जो रेप का केस है। उसको सही करने के लिए ये होटल पे गई और वहां पे एविडेंस टेम्परिंग किया। उसमें वो एक्यूज और होटल को एक्यूज थे। उन्होंने ये एडमिट किया और जो फैब्रिकेटेड डॉक्यूमेंट था वो ऑलरेडी रिटेन हुआ।
So आपके हिसाब से पूजा उपाध्याय when came to the hotel.
Hotel, after the registration of FIR of 376,
Ah.
she went to the hotel, she manipulated the hotel registered record along with the co-accused hotel staffs, and after that he was in judicial custody, so I filed on behalf of him an FIR to the same police station, an FIR registered under 450/23. Under 420 IPC, Your Honor.
वो FIR इसमें चैलेंज है.
Yes, Your Honor. उसमें मैडम क्या हुआ कि जब यहाँ पे आया मैंने प्रोटेस्ट पिटिशन फाइल किया और उस पे कॉग्निजेंस हुआ पूरा स्पीकिंग ऑर्डर से। फिर उनको समन हुआ, 2 अवेलेबल वारंट हुए, फिर लास्ट में जाके एनबीडब्ल्यू हुआ। यहाँ पे कोर्ट में यहाँ पे आए थे एनबीडब्ल्यू को स्टे करने के लिए, क्वेश करने के लिए, जो हाई कोर्ट ने यहाँ पे रिजेक्ट कर दिया, जो कि मेरे पास ऑर्डर कॉपी भी है इसी हाई कोर्ट का। फिर ये सुप्रीम कोर्ट गए, वहां पे स्टे किया गया पूरे प्रोसीडिंग को लास्ट 1 ईयर से, और फिर बाद में वहां पे डिसमिस हो गया, वहां पर भी एसएलपी इनका डिसमिस हो गया। तो अब मैटर यहाँ पे है मैम, और जो ये कह रहे हैं कि मैं यहाँ कॉपी नहीं रिसीव कर रहा था योर ऑनर, मैं एक स्टूडेंट हूँ, मैं अपने परमानेंट एड्रेस दे करके मैं अपने कॉलेज में रहता हूँ।
आप यूपी में हो?
यूपी में मैम। तो ये इनको कोर्ट ने मैम 2 डेट पे 16/12/25 और 21/1/2026 को 2 बार कोर्ट ने कहा कि इलेक्ट्रॉनिक मीडियम से कोर्ट कॉपी को इनको दिया जाए मुझे। लेकिन
ठीक है,
इन्होंने
ठीक
क्या किया मैडम, परसुएड करने के लिए सिर्फ स्पीड पोस्ट से भेज रहे थे और ईमेल आईडी से नहीं मुझे भेजा।
email ID
फिर
Speed post is the actually the
यस मैम, लेकिन
procedure.
ऑर्डर शीट में लिखा था मैम कि आप इलेक्ट्रॉनिक मीडियम से भी इनको सबमिट करिए, लेकिन इन्होंने नहीं किया। क्यों? बस इनको एक्स पार्टी इसको स्टे चाहिए था। बाद में जब अबेयांस में चला गया प्रोसीडिंग लास्ट डेट में 27/2/2026 को, तो मैं ट्रायल कोर्ट में गया, पता किया तो पता चला स्टे हो गया अबेयांस में। तो मैं यहाँ पे खुद ही मतलब रिसीव किया इनका
ठीक
कि
है, वो बात ठीक है।
Your Honor.
आज क्या करना है?
आज मैम यही, आज मैम
Item number 50 में
51 में
Mr. Pandey wants to file an affidavit.
Yes,
But what affidavit? It is for quashing of the FIR.
yes, Your Honor, but my lord, एक short date दे दे, 2 दिन का ही दे दे, हम 2 दिन में सब complete कर लेंगे, party is there.
Right. What is the purpose of
That's
affidavit?
what I also.
Yes, yeah.
Quashing of FIR, I'll see whether the FIR makes out a cognizable offense.
एक just मैं दे देता हूँ, copy दे देते हैं, then हम hearing कर लेते हैं।
So when do you want? When can you file it?
2 दिन, monthly.
Okay, then we will get it listed on 2nd of September, next week.
Milord, kindly. 9th of September, Milord, kindly be fixed.
9th of,
9th.
ठीक है, बुधवार. Okay, heard.
9th is Wednesday. I think
Uh,
Lordship will be
eight-
busy because this matter. Make it
Milord,
either
8th.
Thursday or make it Thursday or Wednesday. So it will be beneficial for you. Tuesday or Thursday. It's a hearing day. You can get enough time. to
Actually, my lord, I am not available on 9th actually.
Lord, I am
because I am
Eight-
going
eight-
to the-
eight-
It's up to you. You decide on a date.
7.
Seven. Make it on Tuesday or Thursday so that you can.
7th is a Monday or Friday, जो भी लो. 8th, Thursday.
Yes.
Hearing date will take some time.
That's what I'm saying. For their benefit, I'm saying.
Thursday? Okay. You heard the petitioner in person, you write it in item number 50. Heard the petitioner in person. Mr. U Pandey, learned counsel appearing for respondent number 2.
That is-
Seek some further time to file the affidavit in opposition. However, he had taken time on earlier occasions too, but had not filed their affidavits. And this is the last opportunity given to the learned counsel to file their opposition, file their affidavit. List this matter on 7th of what?
Eight,
On
eight, eight,
8 of September 2026, by which date the respondent number 2 would file the affidavit
Milord, one more request.
without fail. And fail, item number 51, Mr. M.
I'm appearing for a petitioner here.
Yes, M. Nat, Mr. M. Nat, you are appearing for Pooja Upadhyay,
Yes,
right? Heard Mr. M. Nat, senior counsel, appearing assisted by Mr. A. Bhattacharjee, appearing for the for the petitioner, and Chandramani, who is Chandramani?
Yes,
You, and you are in person,
yes ma'am.
as well as heard the petitioner in person for as respondent number 2. Respondent number 2
One.
or respondent number 1. Here, pleadings are complete, whatever.
The copy right now I have given the
Uh-huh,
copy, my lord.
yes.
Lordship kindly note that, my lord.
Okay.
ये जो अबेयांस ऑर्डर है योर ऑनर, उसको हटा दिया जाए क्योंकि मेरा जो ट्रायल ऑलरेडी 1.5 साल से मैम पेंडिंग चल रहा है।
Abeyance means the NBW is kept in abeyance.
मैं हाँ यस मैम, होल प्रोसीडिंग इज अंडर द अबेयांस।
We will see when the matter is
Finally,
taken up.
it will come on a. Yes.
This on it.
Then we get the
will
order.
hear the entire thing. Okay, so respond number 2, Mr. The copy of the petition was handed over to the respondent number 2 during
The proceeding today.
during the proceeding today. List this matter
On it.
on 8th of September 2026.
Milord,
For
one more
hearing.
request, Milord, kindly. Matter may not be adjourned for any trivial reasons, Milord, on 8th.
on 8th, and endeavor will be made for disposal of the matter.
Milord, yes.
Much more.
Yes. 13. It will is about. Yes, Mr. Majumdar.
Lordship, it's a division lordship against the appeal
Hmm.
in a DB case, lordship,
Hmm.
domestic violence case, where the trial judge has, trial magistrate has compensated. past
So there was a
of rupees
criminal
1 lakh.
appeal, right?
Lordship,
Appellate order is there
lordship, I have annexed that.
by you are for the husband,
I am for the husband,
by Joynal Abedin.
Joanal Abdi.
So what happened?
But while the appellate court lordship that dismissing my petition without discussing anything evidence lordship while disposing the same, which is against the lordship honorable apex court repeatedly held that in a revision petition, Lordship, this honorable court may. Lordship-
First of all, show me the order passed by the trial court or whatever, first court.
Lordship.
Where is that?
Order of the trial court, Lordship, kindly operative portion adjust to save the time, Lordship, page 63.
Yes.
Lordship, may I read, Lordship?
Wait, I'll just see the
compensation under
operative portion. Where is that? Okay.
Page 63, Lordship.
Paragraph 37.
Paragraph C, Lordship.
Okay.
37, last C, Lordship. Upon perusal of the affidavit disclosure of assets and liabilities of both the parties, it transpires that the respondent number one, that is I myself, was working as a store manager at the pharmaceutical store with a monthly income of rupees 10,000 to rupees 20, but that he was terminated from the said job on 5/4/23, and since then he has been unemployed. Keeping in view of the above findings, the respondents are hereby directed to make payment of rupees 1 lakh only as a compensation towards the aggrieved person, which will also include the cost of litigation incurred by the her during the pendency of proceedings of the instant case within 30 days from the date, Lordship. Thereafter, Lordship, I filed the appeal. There was all along stay, Lordship.
1 lakh.
And she is a teacher, Lordship, working in Adarsh Vidyaniketan School.
Achha, so you were directed to pay 1 lakh
1 lakh
as compensation
compensation,
under section 22.
22. But
So you have challenged this.
Lordship, by filing an appeal before the district judge Kamrup, Lordship, which
So
was
appellate court, what happened? Upheld.
appellate court upheld without discussing anything evidence, Lordship, on perusal, Lordship, page 80.
Okay, let me issue notice.
And in the meantime, Lordship, all along the stay was there before the learned court below, Lordship. I pray, Lordship, that.
That doesn't mean that now also you'll get a stay.
No, I am not on that because 1 lakh rupees, Lordship, I am an unemployed youth.
No, that was considered that you were not employed, you were out of your job on this particular day.
And
But-
at this stage, Lordship, I pray, let a notice may be issued, and in the meantime, till returnable date, Lordship, the impugned judgment and order may kindly be stayed. Otherwise,
On what ground?
on the ground that the court all along stay was there, I am not on that. But rupees 1 lakh, he at this stage, he is not in a position to. And the learned court below, there are
Achha, show me the DV Act, also domestic violence. Act.
and learned court below, Lordship, appellate court also did not consider the entire evidence, Lordship. Kindly peruse that page 80, where page 80, paragraph 10, Lordship. Discussion of the trial court, Lordship,
80, yes.
80. That
Page
is the
5
TCR
for
repeat by
determination.
so and so appellant to pay so and so. Then discussion of the trial court. Where is the evidence, Lordship? Nothing was discussed. For both the,
No, the findings of the trial court with regard to 1 lakh, then.
Lordship, last line, Lordship, trial court, page 83, paragraph 16. The trial court found that the appellant along with his in-laws respondents committed an act of domestic violence upon the aggrieved. After considering the rival contentions, I arrived at the conclusion that the aggrieved might not left the society of the without reason, the FIR so and so, so and so. There was no discussion on the, in view of the above discussion, the learned trial court has discussed above, and as such, no interference is required. The impugned final order dated so and so passed by the learned judicial magistrate first class, so and so is affirmed, and paying to set aside the impugned or final order is rejected. As such, no interference is required. Dismiss the appeal for want of merits. Without discussing anything, Lordship.
So once a court finds that there is commission of domestic violence,
Lordship.
it can pass any order. The trial court found proof of commission of domestic violence.
Lordship,
as such,
without,
it has
where is the
passed
evidence?
final
Lordship?
order.
It will, Lordship, at the time of admission stage or hearing stage, Lordship, I will establish this.
No, but for a stay, it is not a matter
For-
of routine.
Lordship, not for the routine, but my respect to submission, Lordship. If the stay order will not be there, Lordship, he will be in troubles, Lordship, because there is a there is a restitution of conjugal right petition is also pending before the learned court below.
Filed by the husband.
Husband, as well as the wife also filed a petition for divorce. And the learned trial judge, Lordship, trial magistrate has restrained the husband from there is no chance of any amicable settlement which is already closed by virtue
It's
of this.
okay, but as far as 1 lakh, I will decide on the staying that order.
At this
only
stage,
on
Lordship,
evidence.
Lordship, petitioner is not in a position to Lordship. If your Lordship, with all respect, Lordship, he is an unemployed Lordship, and the court, learned court, Lordship, the trial court.
Wait, let me see section 22. Of,
And the appellate court, Lordship, also did not consider the evidence properly, Lordship, without, I am relying on apex court judgment, Lordship, page 24. I read, Lordship, from the affirmation.
1 second, do you have the Domestic Violence Act?
Lordship, I have.
Just give pass on. What is section 22 of DV Act? Just show me that. Just pass on the book.
And she is the employee, Lordship. She is getting 44,000 per month, Lordship. So,
Asset and liability are seen of both the parties.
Lordship.
22 is what? In addition to other reliefs as may be granted under the resident, may on an application being made by the aggrieved person pass an order directing the respondent to pay compensation and damages for the injuries, including mental torture and emotional caused by the acts of domestic violence. Acha, this
And
is.
part, Lordship, one thing, Lordship.
Acha, listen to me. Whether there is any application by the aggrieved party
For
for compensation?
not yet, Lordship. Only petition, that is domestic violence petition, Lordship.
Where is that petition?
Annexure, Lordship, page 21, Lordship.
Where are her reliefs?
Relief page, Lordship.
Okay, maybe, so this is grant of compensation of 2,50,000. Where is the relief?
It was an interim relief.
No main relief?
Main relief, Lordship, domestic violence, order we passed, order there.
Yes, compensation order under
Same,
22.
Lordship, under section 23 of the International Justice. That part, Lordship, I'm the learned code.
This is what? This is complaint petition.
Complaint petition.
Acha, have you seen into case laws like whatever is given in 22? In addition to magistrate may on an application being made by the aggrieved party, whether this will be considered as an application or there has to be a separate application.
No, there was no separate application.
Under the law, whether there has to be a separate application.
That part, Lordship, before.
What data part? Whether there has to be a separate application. Have you gone into that respect?
That section 22.
Section 22. So
Section-
if there was no application,
Yes,
then the disorder is bad. On that ground, you could have got a stay.
Lordship.
Stay is not a matter of routine.
Routine, Lordship, but that part, Lordship, section 12(1) may kindly peruse. Domestic incidents report must have to taken into account. But here in this case, Lordship, there is no such consideration. Even.
Incident report was not there.
No, Lordship, even he was not examined. Just I am referring, Lordship, page, in the judgment of the trial court, Lordship, just I am.
Okay, but we will hear the entire case later. Heard Mr. K. Majumdar, learned counsel for the
Page 46,
petitioner.
Oh, sorry.
Petitioner and state is a party.
Yes, Lordship.
Okay.
Yeah.
And Mr. K. Bosho, learned APP appearing for respondent number 2. By this application, filed under section 438 and 442 of the BNSS, read with section 528 of the said act, the petitioner has challenged the judgment and order dated 17/7/2026, passed by the learned additional session judge number 2, Kamrup, within bracket M, Gauhati, in criminal appeal number 135 of 2024, by which the order of the learned judicial magistrate was upheld. Full stop. The petitioner has also challenged the order dated 17/7/2026. What, 17/7?
17/7 is the order of additional session judge. And
No, no.
25/10
Dated, huh?
25/10/24 is the order of the learned judicial.
Where is that? Where is that? Page?
I have annexed that lordship, page. Page 35 lordship. 35 onwards lordship, it is finished up.
Yes, has also challenged the order dated 25/10/2024, passed by the Judicial Magistrate First Class
Kamrup lordship.
in Miss Case number 72 of 2021, by which the petitioner, the petitioner is directed to pay a one-time compensation of rupees 1 lakh to the aggrieved person within a period of 30 days from the date of the said order. Full stop. Issue notice. Upon respondent number 1, the petitioner to take steps for service of notice upon respondent number 1 by speed post or with AD or by usual process. Call for the trial court records. It is the case of the petitioner that the compensation amount of rupees 1 lakh, which was directed to be paid by the petitioner to the aggrieved party, was passed without considering the evidences on record. The learned counsel submits that the aggrieved party is working what?
Working as a teacher lordship.
Is working as a teacher
in other
and
states.
was earning
More than.
more
about
than
50,000 lordship.
earning more than 50,000 per month. Full stop. He further submits that although the petitioner was working in a company, right?
Yes, lordship.
Where did I see that? Although the petitioner was working in the
Page 63 lordship. And pharmaceutical store.
was working as a store manager at a pharmaceutical store, but his job was terminated on 5/4/2023, and that since the said date, the petitioner is unemployed. Looking at the financial constraints of the petitioner, and during the pendency of this revision petition, in the interim, the said direction that the petitioner should pay an amount of rupees 1 lakh as compensation to the aggrieved party is state. List this matter after 2 weeks on a date to be fixed by the registry. You take steps.
Lordship.
Yes.
This is an application for quashing of the charge sheet. The allegation against the accused is under the
These are motion matters.
motion.
নহলে bail hearing থাকি যাব না? Yes, this is for quashing of the
Quashing of the
charge sheet.
charge sheet, quashing of the charge sheet, the charge sheet is at page 42.
This is POCSO.
POCSO section is there, madam.
Let the notice go.
Yes, madam.
Notice have gone or what?
No, my lord, first time.
Heard Mr. H. Gupta, learned counsel for the petitioner, and Mr. K. Busher, learned APP for the state. By this application, filed under section 528 of BNSS 2023, the petitioner has challenged. Petitioner has prayed for quashing of the charge sheet.
Number 30.
Petitioners have prayed for quashing of the charge sheet filed against petitioner number 1, white charge sheet number 399 of 2025, dated 31/12/2025. under section 317, subsection 2, /74/75, subsection 2, /76 of the BNS, read with section 10 of the POCSO Act. Since the offense, since the charge sheet, since the charges were leveled against the petitioner number 1 for offenses under the POCSO Act, the notice to the respondent number 2 becomes
My
mandatory.
lord, here, my lord, in this case, my lord, jointly, my lord, filed the informant and my lord, the accused jointly filed the, my lord. So, my lord, that part will not come, my lord. Only, my lord, scan TCR may be called for, my lord.
So this, no, Zakir Hussain and Abdul Salam,
Yes.
the victim is not there. Acha,
Victim
acha.
is not there.
Father,
Father has,
father of the victim.
victim has
Who is that? Two.
two, my lord.
It is a joint petition for what? For settlement,
Yes, my lord.
POCSO matters.
Lord, not on that, my lord, although it is not compoundable, on the materials, my lord. There were no sufficient materials, my lord. On that.
Any judgment that POCSO matters are settled on
No,
agreement?
Not on that, my lord. I'm not on that. On the merits, my lord,
On the merits.
on the contents of the charge sheet and the,
Then how come you both are together? Not on settlement.
settlement is also there, my lord. Both things are there, my lord. But settlement,
Both things be there.
that is,
You are the petitioner here, you are the accused person, Abdul Salam, right? And the father of the victim is Zakir.
my lord.
So both of you have come as a petitioners here.
Yeah, my lord, this is,
So for what? For quashing of the charge sheet.
yes, my lord.
On what ground? Settlement.
Settlement,
And you are saying also on merits.
my lord, my lord.
You be clear and then we will hear on some other day.
No, my lord, settlement is there, my lord, but as my lord, the law is clear that it cannot be compounded. But, my lord, they have come together, my lord. That part is, we have not.
So if it cannot be compounded, see.
They can file a petition together. my lord.
No, there will be judgments if the trial will have no effect, if the trial will be a
Yes, ma'am,
purposeless.
on that ground only, my lord.
Then in that case, okay.
On that
Even
ground.
POCSO cases,
Yes.
what happened? The victim will marry the petitioner or what?
No, my lord, she is of very less.
Young
9
age.
years, 9 years age only. Not on that ground, my lord, but there were the allegations, if I may read, my lord, these are not covering at the definition of section 7. Sexual assault is prima facie not there, my lord. The person accused is 60 years old.
So the father has also said that no case under POCSO.
Yes, my lord, they have under some misunderstanding, my lord, the FIR was filed. If my lord sees the FIR 161, 164, all are
Okay,
contradictory.
show me. Where is the FIR?
FIR, my lord, is at page 9.
Wait, I'll read it myself.
Yes, ma'am.
Okay, he removed her clothes on the road.
This is the FIR. Now, my lord, page 17 is the 161.
161 of the victim.
Victim. No, that completely differs. No, that part is not there in the FIR, which was exaggerated. And last paragraph, my lord, will see last 3 lines. Nearby people inform my father with a notion that he has done bad activities. He had
So, didn't you file an application for discharge during the charge framing? Or did the trial start?
trial start, my lord, charge has been framed.
So, you have made an application for discharge, rejected.
Okay. No, not made, my lord.
Huh?
They have not made any application. Now it is at the evidence stage.
My lord, 183 statement is there. of
And
the
then
victim, my lord.
160, yes, 183 statement, is it? After 161, my lord.
Okay, so where is 160?
Page 25,
Page?
page 25, 183 statement. Question number 3, my lord. The accused is a 60-year-old, my lord. He just had an 11 affection. He just touched the, and she called him as a grandfather. Again, the last line, my lord.
With a notion that he had done bad
Yes.
things.
In both, it is there. In one.
Where is the,
Yes.
and where is the settlement?
Page 36, my lord.
This is addressed to the police.
Yes. And signatures of villagers are there, my lord, and he stated that he in the his FIR was filed out of anger.
This is the settlement. This is
Yes.
exactly not in the, it's not in the form of an affidavit also. Okay.
Required one. There will be.
Okay, let it be quashed.
My lord. My lord, only one my submission, my lord, in 161, my lord. If my lord may kindly peruse the victim 161, my lord. Vernacular part, page 18, my lord.
1-8.
1-8, my lord. Vernacular part, my lord. Ofo ase no dada.
8, wait.
Online
Huh.
to nai.
Yes.
Oxo solis.
Beya kam.
Yes,
To read in Assamese, then to read this way.
my lord.
No? পিছত তেখেতে ৰোগীক দিয়া মেডিকেল প্ৰেছক্ৰিপশ্যন এখন পাওঁ আৰু পৰীক্ষা কৰি চোৱাত গম পাওঁ যে সঁচাকৈ তেখেতে এলোপেথিক মেডিকেল প্ৰেছক্ৰিপশ্যন কৰিছে যিহেতু তেনে এজন ডক্টৰ কৰিব পাৰে তেখেতে মানুহৰ জীৱন লগত খেলা কৰি আছে What is the other reading?
Other is the, my lord, the accused, my lord, statement, my lord, interrogation statement. He also said that, my lord, yes, he used the pad and all these things, my lord. Otherwise.
But probably under further detention is not required. Everything has been seized.
And maybe Mr. Barua has found out something more.
My lord, that may be, my lord. He's not also Borua, my lord. Mr. Sharma actually gone through that. He has already left, my lord.
Let him be on bail.
My
He has not displayed any registration number of
my lord, the
CI.
thing is that, my lord, being a, my lord, B farmer, my lord, he is, my lord, his conduct is like a doctor, my lord. And that may not in rural areas.
We have the habit of getting medicines from the pharmacist. We go to a pharmacist and get the medicine. It's a regular affair. Okay, heard Mr. S.C. Viswas, learned counsel for the petitioner, and Mr. K. Bosher, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Murajhar PS case number 131 of 2026.
Murajar, madam.
Murajhar PS case number
131 of 2026.
2026, corresponding to GR case number 724 of 2026 under section 316, subsection 2, 319, subsection 2, 336, subsection 2, 340, subsection 2, 125/271 of BNS 2023. The FIR in connection with which the petitioner has been arrested
On 25,
was lodged on 30/6/2026 by Dr. Avijit Neog, who was the Anti-Quackery and Vigilance Officer of Assam Council of Medical Registration by stating inter alia that complaints were received by the said cell from various conscious citizens that the petitioner is practicing as a qualified registered medical practitioner and is treating patients from his pharmacy located at Murajhar Hojai without any recognized qualification and registration. It is further stated that the petitioner who claims to be acquired the degree of Bachelor of Pharmacology had displayed various degrees in his certificate. In his certificate or what? No, various degrees, which are not recognized by the medical, which are not recognized medical qualification under the National Medical Commission. Full stop. It is also alleged that the petitioner has been treating patients with allopathic medicines and is displaying a registration number which is not the registration number issued by the Assam Council of Medical Registration. Full stop. Mr. S.C. Biswas, learned counsel for the petitioner, submits that admittedly the petitioner admittedly the petitioner has acquired the degree of Bachelor of Pharmacology, and that after finishing the course of pharmacology, the petitioner underwent
Indian
training.
medical history.
a training under the Indian Rural Medical Association. And in pursuant to the said training, he was assigned with a registration number. Full stop. He submits that the said registration number is not given to him by the Medical Council of India, and that there was no intention on the part of the petitioner to act like a doctor. Full stop. He although prescribes medicines, allopathic medicines to the patients, but he had never claimed himself as a qualified doctor. Full stop. These are your submissions. Par contra, Mr. K. Bosho, learned APP had placed reliance on the statement made by the informant, wherein the informant had stated that the petitioner was acting as a doctor, as a regular doctor, and was giving medicines to the patients, thereby causing danger to the health of the public. He has also placed the statement of the accused person. What did he say there?
My lord, he said, my lord, that he is, my lord, in that practice, my lord, for this, my lord, alias, my lord.
Wherein it is stated that he gives medicines to the patients. মুৰে হয় আগতে পেটৰ বিষ গেছ কেতিয়াবা জ্বৰ আদিৰ প্ৰেছক্ৰাইব কৰিছিলো 2 বছৰমান হৈছে প্ৰেছক্ৰাইব নকৰো ওকে ফুল ষ্টপ Upon consideration of the submissions made by the learned counsels, it is seen that the petitioner was running a pharmacy in the name of New Life Medicos in Murajhar Hojai, and that the petitioner had displayed a registration number, that is number registration number being 137144. But it is also reflected that the registration number was assigned to him by the Indian
Rural Medical.
Indian Rural Medical Association. And it is not the registration number assigned by the Medical Council of India.
Assam.
Assam. Assam Council for Medical Registration, no, Medical Council of India, no. Assam Council of Medical Registration. Further, it is also seen that the petitioner had given his statement that earlier he used to prescribe medicines to the patients, but for the last 2 years he has not. He had stopped this said practice. Full stop. In view of the same, this court deems it fit to enlarge the petitioner on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the
Chief Judicial Magistrate, Ojai Shankardev Nagar.
Chief Judicial Minister Hojai Sankardev Nagar. Under the following conditions, petition is disposed.
Development.
He will appear before IOSIO Diriva. Then 31. Yes.
May I please, your lordship?
Case there is there.
Lordship, last occasion TCR was called for, lordship.
No, scan copy of the trial
Yes,
record has not been received. Okay.
Lordship, in connection with this incident case for last 78 days, I am behind the bar.
What
And
is
the
the
matter
offense?
is pending before the SDGM 1.
So what is the offense?
Often the allegations is under section 351, subsection 2, that is criminal intimidation. Thereafter 351, subsection 3, that is criminal intimidation by threatening to cause death or grievous hurt. Thereafter 69, sexual intercourse by employing deceitful means, etc. And thereafter 89, causing miscarriage without women consent, Your Honor. I would like to inform this honorable court the informant.
But then I cannot take it up unless the records come. There is an order here. Okay. So you will have to wait for some time. Heard Mr. R. Das, Learned Counsel for the petitioner, and Mr. R.J. Borwa, Learned APP for the state. It is seen that the case, that the scanned copy of the trial court records have not been received. As such, the registry is directed to issue reminder for receipt of the same. List this matter on 8th of September.
Shortly, if possible.
Short only. Next week. Next week, there are so many holidays. 8th of September.
Obliged, lordship.
We have received the case diary.
Oh, okay.
Here, FIR is page 8. This person was arrested. Actually, my lord. Petitioner was
Okay, I'll go through the FIR once. What is your name?
The name.
So many.
All our name is.
So many.
Yes.
Ajay, just spell out the names. I mean, tell the names.
Yes.
Barkat Ali,
Barkat Ali.
Mondal.
Mondal.
Then?
Nazrul Islam.
Hmm.
And Rokibul Islam, Elias Rokibul Islam.
Rafiqul Islam.
Yes.
Hmm.
Rokibul. These three persons were in
rubber.
custody, legal custody.
Rubber nahi. Rubber diya na. Rubber nahi. But they are Nazrul Islam, Rokibul Islam.
Yes, ma'am.
Rokibul. And what it is in this item, right? And what about the next item?
Next item.
Nazira Khatun.
Nazira Khatun.
Nazira Khatun, then?
Nazira Khatun.
Who else?
Rafiqul Islam. Elias
Rafiqul.
Minhajul.
Rafiqul Islam, then?
Minhajul. Then Akhtar Hussain.
Akhtar Hussain.
Then A. Kader.
A. Kader. The only one who is left out is Anwar Hussain.
Anwar Hussain. He has
So,
not come. He is not come.
so no bail in respect of this one.
Hello?
No bail application.
No.
Okay.
Now.
I'll read the FIR.
Yes, ma'am. Page 8.
Hmm. Expired.
in hospital.
Okay, so main allegations are against 2 and 1.
2 and 1.
Right, but
The-
only
here-
2.
Here petitioner number 2 and 3, they are
The
listed.
other accused person, it is said that they assaulted him with pieces of betel nut tree. So all of them had assaulted.
No, Losam kindly see, statement of accused petitioner number here, 2 and 3.
Hmm?
2 and 3,
Hmm.
they were arrested first. Then petition number 1, himself surrendered.
Surrender.
Yes, my lord. Then my lord, petition number 2 and 3, as per my information, they stated, they confessed the guilty. They confessed the guilty.
Assaulting.
They confessed the guilty, and other person was not there. Other persons were not there. So my lord, those 2 persons are now.
That statement will not
72 days now they are
in
custody.
jail.
Yes, ma'am.
All the 4.
All the 3 persons.
All the 3.
My lord. 72. So,
What
I
does it-
consider land of detention and
Independent witness?
My lord, yes, one independent witness, my lord, but when he was, my lord, lying, my lord, after getting the sustaining injury, my lord. One person, my lord, he arrived first, my lord, then he took him to the nearby medical, my lord.
No, what about assault?
Assault, my lord, yes, that injured person, my lord, he has implicated 3 persons, my lord. One is the petitioner number 1, my lord, that is Borkat Ali Mandal.
Apart from the husband, there are other injured persons.
No, only one, my lord.
He died.
He died, my lord.
He died.
But when he was, my lord, first met by this witness, my lord, Amir Hamza, my lord, he was in a, my lord, he was in a stable condition, my lord. He was in a position to speak, my lord. Then he has, my lord, mentioned the name of 3 persons, my lord. That is what I am
Yeah,
submitting.
those will be like dying declarations.
Yes, my lord. He has stated before Amir Hamza, my lord, and Amir Hamza's statement, judicial statement recorded by the, my lord, before the, my lord, magistrate, my lord.
Acha, where is Amir
but-
Hamza? I have not got his name anywhere.
Amir Hamza, he is one of the
Witness.
witness, my lord. Witness, my lord.
It is not reflected in the FIR.
No, he is the witness, my lord.
But this.
No, the informant had not stated anything.
No, my-
Okay. Amir Hamza is one of the witness and he stated that when he took the injured person to the
Take him to
hospital.
the nearby medical hospital, my
Hmm.
lord. Then, my lord, he has, my lord, implicated, my lord, Borkat Ali Mandal and his 2 sons, my lord. That is the petitioner number 2, my lord, in BA number 2051.
So Barkut Ali and
And
his
his
2 sons.
2 sons, my lord. One is Nozrul, my lord,
Hmm.
and another is, my lord, that is the petitioner number 2 in the AB, my lord.
Okay,
His name is Rafiqul Islam Minhajul, my lord.
okay, okay.
So I am opposing, my lord, bail application against 3 persons, my lord. And regarding, my lord, the other anticipatory bail application, Nazira Khatun, my lord, she was on interim, my lord. She has already appeared. Her statement also recorded, my lord. And regarding the other, my lord, petitioner, my lord, I leave it to your lordship, my lord. But regarding these 3 persons, my lord, I am opposing, my lord.
So these 3 means Barkat Ali and his 2 sons.
2 sons, my lord.
2 sons.
That is the, my lord, petitioner number 1, petitioner number 2.
Yes, petitioner accused number 2 had assaulted. It is specifically stated in the FIR.
Yes.
And Amir Hamza have also said about the dying declaration
Yeah,
by the husband of the victim, or
My-
husband of the informant.
my lord.
So, my lord, Borkat Ali
Because
Mandal-
people have not seen the assault.
PPL, my lord, otherwise, my lord, the statement recorded, my lord.
See, oral
But they
dying
have-
declaration will require again corroboration.
6:30 PM incident token, 6:30 PM.
But that, my lord, trial could, that will be considered at the time of trial, my lord. Now, my lord, what are the prima facie matters that has been collected by the
I
investigator?
have no objection, my lord. I have no
Okay.
objection.
So
And
you
let this 3% go. And now, so far as petitioner 1 is concerned, and 1, 2, and concern, 1 and 2 and concerned, they're already 72 days. By considering length of redemption, my lord. Maybe, my lord.
So you're not objecting to rejection of bail in case of Barkat and his 2 sons?
My lord.
Barkat and his 2 sons, no bail, and others, okay. You are agreeing? You are agreeable?
I agree on that, but yeah, but so far as Bogota other 2 sons is concerned, 1 son is in anticipated. I am not questioning his. Let his will
He be arrested.
rejected. I will later on. So far as this petitioner is concerned, 1, 2, and 3, already 72 days are there.
Regarding 3 also, my lord, I leave it to your lordship, my lord.
This is not
It's
involved, not at all.
No, Rocky Bull.
Yes, my lord, not at all.
A Rocky Bull, my lord, yes, Rocky Bull.
This is the statement of the dying declaration only.
Hamza,
Yes, my lord, Hamza, my lord.
Amir Hamza.
He has implicated, my lord. He was the first person, my lord, Who took him to the, my lord,
Hospital.
hospital, my lord.
Others are not there.
And others, my lord, that is, my lord,
Okay.
there's somebody have seen, my lord, but not directly.
Actually,
The assault part, assault part nobody has seen.
I query my client, my lord, actually two persons are there.
Wait, on his.
Because, my lord, other witnesses said, my lord, these two accused person, they were present in the court, my lord.
Two persons are there, and they confess.
But accused number 2, of course, had inflicted blow with wooden baton and result.
My lord, my lord,
Accused number 2 has been inside for how many days, you said?
72 days.
Huh?
72 days.
17?
2 days.
172 days.
No, only 72 days.
Oh, 72 days.
So, my lord, by considering land of detention, our statement has been recorded.
Okay, heard Mr. J. Ahmed, learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state. By this application, the petitioners, 3 in numbers, namely Barkat Ali Mandal, Nazrul Islam, and Rokibul Islam, alias Rokibul, same, Rakibul, R.A., Rakibul Islam.
He is a son of, actually,
They prayed for bail in connection with Kolgechia PS case number 55 of 2026, registered under section 103/612/35 of the BNS 2023.
My lord,
The FIR, oh yes, you want to say something?
I'm bearing for my lord, private respondent, informant, my lord. Regarding my lord, length of detention against arrested 3 accused, my lord. Actually, my lord, I would like to objection on that specs because we all are belongs to the same locality, my lord. And there is a chances after their release to tampering with the witnesses' evidences, my lord. So, my lord, at this stage, my lord, at least, my lord, primary witnesses, my lord, after examination of my lord, primary witnesses, then my lord, their bail may consider, my lord. Because, my lord,
But I have not decided yet. Let me dictate and then I'll decide. Okay, then, bail, no, in connection with so.
There is no chance.
Oh, yes. The first information report in connection with which the petitioners were arrested was lodged by was lodged before the officer in charge of Barbhita Police Outpost on 3/6/2026. By which the informant had alleged that while her husband was returning from a market by riding his motorcycle, the accused persons, who were 8 in numbers, as arrayed in the said first information report, assembled at a particular place, armed with wooden sticks, and in furtherance of a conspiracy. Accused number 2, that is petitioner number 2, inflicted a blow with an wooden baton, and as a result of which the husband of the informant fell on the ground. Full stop. The informant also stated that thereafter all other accused person had assaulted her husband, causing serious injuries. Full stop. The informant also stated that her husband was taken to the hospital, to the local health center, and thereafter to Borbetta Medical College and Hospital. But during the treatment, her husband expired. Full stop. The learned counsel for the petitioners submits that the petitioners were inside the jail for 72 days and that their statements were also recorded, and investigation is also at the final stage. He submits that no overt act is mentioned with respect to petitioner number 1 and 3. And the only overt act, OVERT, that is mentioned was with respect to petitioner number 2. But he submits that petitioner number 2 has been inside the jail for long. As such, he has prayed for bail in respect of all the petitioners. On the other hand, Mr. R.J. Borua, learned APP for the state, submits that R.J. Borua, on perusal of the case diary, submits that one independent witness, namely Amir Hamza, had stated that while he was taking the injured husband of the informant to the hospital, the injured person revealed the names of petitioner number 1 and 2, along with another, to have assaulted him. As such, he objects to the bail. He objects that bail may not be granted in respect of petitioner number 1 and 2.
My lord, I'm sorry, my lord. There are 3 persons, my lord, whose my lord 183 statement have been recorded, my lord. They all has implicated, my lord, because my lord injured person is also stated before them, my lord. They are, my lord,
Oh.
one is Amir Hamza, my lord.
He also submits that apart from Amir Hamza, there are 3 more witnesses.
No, 2 more.
So there are 2 more witnesses
Namely,
who had stated about the statement made by the injured,
injured person,
statement made by the deceased person.
my lord.
He as such submits that there is an oral dying declaration in the instant case, and oral dying declaration in the instant case implicating petitioner number 1 and 2. Right? Mr. A.K. Azad, learned counsel appearing for the informant, submits that the incarceration in the jail by the petitioners cannot be a ground for bail. And he submits that after the trial is conducted, and he submits that after the trial reaches to certain extent, their bail may be considered, but not at this stage. I've heard the counsels and I've gone through the records. In the FIR dated 3/6/2026, it is specifically mentioned by the wife of the husband, or wife of the deceased, that petitioner number 2 had inflicted blows on the husband, which had resulted in injuries upon her husband. He also stated, or she also stated, that thereafter all the other accused persons, including the other petitioners, to have assaulted her husband, resulting in grievous injuries, and which had ultimately resulted in death of the deceased. Full stop. Although section 3, subsection 5 is inserted in the present case, but then the fact of seeing the common object is a matter of trial. Okay, petitioner number 2 will be inside, but all others. Further, there is a specific statement that petitioner number 2 had given the first blow, but it is not certain. But it is certain that the deceased died due to many blows given by other persons. As such, this court deems it fit to release, to enlarge the petitioners on bail, on furnishing of a bail bond of rupees 20,000 each with 1 local surety each, to the satisfaction of the SDJM Borpeta, the Chief Judicial Magistrate Borpeta. Okay, under the following conditions. AB,
My lord,
petition by two, my friends say.
one, my lord, she has appeared, her statement recorded, my lord. I'm opposing two, my lord, because two has been.
তুমি এবি ধৰি লিখিবা ক লিখা heard Mr. so and so to একে হ'ব then you say that by this application the petitioners who are 4 in numbers have paid for pre-arrest bail in connection with Colgatia PS case number 55 of 2026 registered under section 103/61(2). Same case number, right?
Same.
But why am I finding lesser sections here than that? 61(2) as well as section 3(5). Tinta asil na purna to 3(5) of the BNS 2023. The first information report in connection with which the petitioners are apprehending arrest was lodged by the wife of the deceased on 3/6/2026, stating inter alia that while her husband was coming back from the market, the accused persons assembled at a particular place, and when her husband reached the spot, accused number 2, that is accused number 2, namely Nuzrul Islam, Nuzrul, Nuzrul Islam, had hit her husband with an wooden baton, and that thereafter other accused person have assaulted her husband, resulting in her husband's death. Mr. J. Ahmed, learned counsel for the petitioner, submits that no overt act is mentioned with regard to the petitioners, and that the only overt act that is mentioned was with Nuzrul Islam, who was arrested by the police. On the other hand, Mr. R.J. Borua, learned APP, on perusal of the case diary, submits that one of the petitioner, namely Rafiqul, right? No.
Petition number 2.
Who is the son of?
Barkat Ali Mandal.
Who?
Petition number 1.
No, Nazira Khatun is one.
His mother. His mother.
No. Who is the son of Barkat Ali?
In
Barkat
anticipated,
Ali's son is not there.
anticipated bill, my lord. Rafiqul Islam, son of Barkat
Petitioner
Ali.
number 2 submitted that petitioner number 2 had attacked the husband of the informant at the first instance, and thereafter all other accused persons had assaulted the deceased, and as a result of which the deceased died. However, he submits that as far as petitioner number 1 is concerned, she was enlarged on interim pre-arrest bail by order dated 27/2026, and pursuant thereto, said petitioner number 1 appeared before the investigating officer and her statement was recorded. Full stop. It's okay, yours is okay. Then Mr. A.K. Azad, learned counsel for the informant, however, submits that it is writ large, WRIT, writ large in the FIR, that all the petitioners have collectively assaulted the husband of the informant, and that the husband died as a result of the said assault. I have heard the counsels and have gone through the records. It is seen in the FIR that overt act is not mentioned in respect of any of the petitioners. That is petitioner number 1 to 4. However, as far as the common object is concerned, the same is a subject matter of trial. It is also seen that specific act or the attacks were not stated in respect of the petitioners individually by the informant.
Regarding petition number 2, my lord, they have witnesses is implicated, my lord. Rafiqul, my lord. Rafiqul,
Yes.
I'm opposing.
আচ্ছা এই য'ত আৰজে বৰুৱা কৰিছে তাতে এটা লাইন এটা এড কৰা the learned counsel have also submitted that independent witnesses who had taken the deceased to the hospital had stated that petitioner number 2 had stated that the deceased person revealed before them that petitioner number 2 had also assaulted him
Along with the others.
as such along with others, huh? And as such, he opposes the bail to be granted to petitioner number 2.
Well.
তাৰপিছত তললৈ আহা। Although in the oral dying declaration of the deceased person, the name of the petitioner number 2 was taken. He said that Barkat Ali and his 2 sons.
No, specific name mentioned, my lord.
Oh, name mentioned.
Yes, yes, my
Okay.
lord.
His
That is
date.
why I'm opposing, my lord.
Huh. But in the said FIR, the same was not written. And it is also a settled position of law that only on the basis of oral dying declaration, complicity cannot be ascribed. In view of the same, this court deems it fit to enlarge the petitioner on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with one local, each with one local surety each of the like amount to the satisfaction of the arresting authority under the
And
following.
regarding petitioner number 2,
They
my
will
lord.
appear before the arresting authority within 7 days, or if they fail with the conditions, then bail will be cancelled.
Petitioner number 2 against his.
There are sufficient,
but-
sufficient materials, my lord.
Oral dying declaration and what.
That
you
is the
have stated.
investigation stage, my lord. This is not trial, my lord. Investigation stage, my lord. This can be considered, my lord.
Considered, yes. But okay, there are some distinctions, some discrepancies. Yes. Bail is a rule, exception, non-giving is an
But
exception.
the prima facie material also has to be considered, my lord. While
In case
like granting and my lord anticipatory bail, my lord, not regular bail, my lord.
they will have to appear within 7 days. 32. Yes, 32.
32, my lord, search is submitted, my lord.
Rashid submitted,
My lord.
but the council is not there. K. Borua, M. Alam. None appears on call for the petitioner. However, Mr. R.J. Borua, learned APP for the state, submits that the charge sheet in the instant case has been laid by charge sheet number
My lord, 58/2026, dated 24/5/2026.
yes, so and so. But however, for the ends of justice, list this matter again on 2nd of September. 35. না 33 কি হল? 33 madam? Thirty-three is mentioned, Mr. Borua.
It is not mentioned person.
Okay, 35. What is about 34 or 34 mentioned? But 33, I don't think so. 33 are there?
Yes, yes.
Oh, yes. So come forward, tell. What happened?
33, my lord, this accused person, my lord, he was on interim, my lord. And my lord, I was paid for some time, my lord, to produce the case there, my lord.
Acha, acha. Okay. Heard, Mr.
H. A. Rashid.
H.R. Ali, learned counsel for the
H. A.
petitioner.
Rashid.
Huh?
H. A. Rashid.
H.A. Rashid. H.A. Rashid, learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state. Mr. Borua submits that the case diary has not been received and has prayed for another date for placing the same. Prayer is allowed. The interim list this matter on 8 lamba date 15th of September. 15th of September 2026. The interim order passed earlier shall continue until the next returnable date. 35.
In this case, my lord, earlier, I think,
Up to date CD was called for.
CD was called for, my lord, not received, my lord,
Not received.
not received, my lord.
Same. Mr. Heard, Mr. A.K. Azad, Learned Counsel, and Mr. Borwa submitted a order.
Interim is there, ma'am.
Interim order shall continue until the next return date.
14/9.
When? 14/9.
14/9.
Okay, 14/9, 14th of September. Yes, Mr. Mohanta, Ms. Chaudhary, you all are waiting for which matter? It's already 4:30. 62. Supplementary. It's adjourned. 62 supplementary is adjourned.
62 perhaps not adjourned, my lord.
Acha? Oh, Miss M.K. Brown is there.
Yes, your lordship.
But somebody mentioned in the morning, what is that?
Oh, your lordship.
Oh, okay,
Yes,
for
sir.
calling the affidavit.
Yes, your lordship.
Okay, okay. Okay, we will take it up. We will take it up. 62 Matibani, Mohantara, 62. And Miss Chaudhary, what you have?
My item is item 28. And
28.
28 admission matter, your lordship may not take up this matter, but today another matter, connected matter has been listed before court number 23. So we prayed there to list all these matters on 15th September.
Okay, fine.
And when lordship in this matter notice was issued, scan copy of the TCR was not called for, but in other all matters TCR was called for.
There will be one TCR only?
No,
Or what?
three different
Connected,
NIA
but three
cases.
different cases.
Acha, yes or no?
Item 28.
28. Heard Miss R. Chaudhary, Learned Senior Counsel assisted by Miss S. Ahmed, Learned Counsel for the petitioner, and Mr. S. Nawaz, Learned Counsel for respondent number 1, and Mr. R.J. Borua for respondent number 2. Miss Chaudhary submits that there are analogous matters.
Yes. Which are listed on 15/9/2000.
Many or one or two?
Three
Three
cases,
matters,
total three
lordship.
cases.
In one matter, stay was granted, then notice was issued, lordship. Thereafter, my learned friend filed his wakalatnama. In another two matters.
Okay,
lordship,
let this matter be listed along with
Along
that.
with the other.
lordship,
Okay.
I'll give the numbers, lordship.
Ms. Chaudhary submits that there are analogous matters which can be taken up along with the instant matter, and the number of the analogous matters are.
I'll provide.
Okay.
I
So
can
and
write
so we'll lick it.
criminal
Uh-huh.
petition, my lord, 1020, and criminal petition 1005/26.
Okay, you give the number he will do. As such, she prays that all the matters be taken up together. The said submission is also considered by Mr. S. Nawaz, Learned Advocate for respondent number 1. As such,
In that case, lordship, he has given assurance that before the learned trial court, he will not object, lordship. That may.
Okay,
kindly
it is
be
fair.
recorded.
That I am also submitting here. The
Okay.
case is fixed on 3rd. If they file an adjournment application, we will not oppose that. That has already been reflected there.
as such, prayer is allowed. List this matter along with the other matters.
On 15th.
It is also submitted that the other matters were fixed on 15th of September.
September.
15th of September 2026, full stop. Accordingly, this matter be also listed along with the same, on the same date.
Lordship.
And when a scan copy of the TCR may be called for.
Required.
Yes.
Yes, lordship. On 11.
There is also a prayer for calling of the trial court records, which is allowed. As such, call
Scan
for
copy.
the scan copy of the trial court records.
Lordship.
List this matter on 15th of September.
Lordship, before 15 on 3rd of September, this matter is fixed before the learned trial court. So that recording, that may be recorded that they will not object before the learned trial court.
No, they will not object. It is so
That
many
has already
people
been
are there.
reflected in the other
Everybody
cases.
attack him.
Yes.
Don't object. It
They will
is
file an
not written
adjournment,
in-
we will not object, madam. That part.
Obliged.
Yes,
deep
Mr.
level.
Mohanta? 62.
I am in interim, my statement was recorded, and last time, my lord, they said that I have not appeared. So that effect, my lord, I filed an affidavit, my lord.
No, my lord, my humble submission, my lord, we have received the case diary, my lord. And from the case diary, my lord, it is not, my lord, clear, my lord, whether he has appeared or not, my lord. So since he is on interim, my lord, so may I pray, my lord, that we'll call for the up-to-date case diary, my lord.
Okay, let the up-to-date case diary come.
And my lord, interim, my lord, continue.
Third, Mr. T.J. Mohanta, Learned Senior Counsel, assisted by Ms. M.K. Brown, Learned Counsel for the petitioner, and Mr. R.K. Borua, Learned APP for the state, R.J. Borua, state. Mr. Borua submits that although he has the case diary with him, but the same is not updated, and that he may be allowed to bring the updated case diary. It is also seen that the petitioner, that the petitioner was enlarged on interim pre-arrest bail And a condition was attached that he should go and appear before the investigating officer for giving his statement. Full stop. However, Mr. Borua submits that statement is not available in the case diary that he has. As such, it is directed that Mr. R.J. Borua would get the updated case diary from the concerned police station on the next date fixed. List this matter on
18th 9, my lord.
18th of September 2026. Interim order passed earlier shall continue until the next returnable date. Just serially matter. Thirty-seven. Case diary is there? Yes. Item
Interim, Lordship,
37.
Lordship.
37, Ayu Chaudhary, yes. You are on interim.
Lordship.
So their statements are recorded. Name is Zakir Hussain and three others. Zakir Hussain, Tajuddin Ahmed,
Nazimuddin and Suman Datta.
heard Mr. Ayu Chaudhary, learned counsel for the petitioners, and Mr. K. Busher, learned APP for the state. By this application, the petitioners have prayed for pre-arrest bail in connection with Rongia PS case number 143 of 2026, registered under section 61 to 196 within bracket 1, again within bracket small a, slash 118 to 109 1 3085 of BNS 2023.
Yes, sir.
Statements recorded?
Recorded.
All four, all three,
Yes, sir.
four. Okay, even Suman Datta.
Yes, madam. Suman Datta also recorded, madam.
Okay, the first the information report in connection with which the petitioners are apprehending arrest was lodged on 9/6/2026, in which the informant had stated inter alia that when he reached, no, when he went to a dhaba to buy food, no, when he went to a dhaba run by accused number 1, accused number 1 is a petitioner.
No, Lordship. Petition number 1, 2, and 3 are brother of accused number 1.
Whatever. Accused number 1, to buy food, he noticed the pictures of various goddesses being kept in the said dhaba, and that the informant asked accused number 1 to remove those photos. And thereafter he collected the food and went home. And that thereafter, on 8/6/2026, he involved himself in an argument with the owner of the dhaba, and pursuant thereof, the accused persons named in the FIR assaulted him. Full stop. It is also seen that all the 4 petitioners were enlarged on interim pre-arrest bail by order dated 2/7/2026. And one of the conditions attached to the order was that he should make that they should make themselves available for examination. And in pursuant to the said condition, the petitioners have appeared before the investigating officer and their statements are recorded. As stated by Mr. K. Busher, learned APP for the state after perusing the case diary. In view of the same, it is seen that the petitioners are cooperating with the investigation, and as such, this court deems it fit to make the order dated 2/7/2026 as absolute, with the further condition that the petitioner should comply with the conditions mentioned in the said order dated 2/7/2026. Petition is disposed of.
My lord, here, my lord, everyone's statement is not recorded, but all are appeared, my lord, that notice there. All appear, but they may take 3/4, may not require others.
Very good. Appeared before the
Appeared.
ayobili likhe diba.
Yes, my lord, on 8/7 they appeared, my lord, that notice.
As stated by K. Goshabli Koluze,
My-
that all the petitioners had appeared before the IO.
My.
Yes. 38. Is there there?
The item 38, my lord, CD not.
CD not received, you're an interim. Heard Ms. S. Neo or S.G. Borua, learned counsel for the petitioner, and Mr. K. Bosher, learned APP for the state, and Mr.
May I please, Lordship, I am for informant, Lordship. I will file written objection.
What written objection?
Lordship,
You can at best assist DPP.
Lordship, because Lordship
Informing
accused,
job is only that.
accused petitioner, Lordship, threatening informant as well as his family member, Lordship. In this regard, and complaint was filed before this jurisdiction.
Achha, this was after they were enlarged on interim
Yes,
bail.
yes, Lordship. Yes.
Also, that will amount to a cancellation of bail. You can file an independent application for cancelling the bail on that ground. But it cannot be in this. You are an informant. Your prayer will not be considered in this application. Only her prayer will be considered. You file an application for cancellation.
Yes, Lordship.
And Mr. What's your name?
H.A. Rashid.
HR?
H.A. Rashid.
H.A. Rashid, learned counsel for respondent number 2. Mr. Bosho submits that the case diary has not been received and has prayed for another date to place the same. Prayer is allowed. Place this matter on.
Heard, my lord. Interim is there.
Interim.
16.
Place this matter on 16th of September
16th of
2026. The interim order passed earlier shall continue until the next returnable date.
May I please, your Lordship? My lord, there are no interim, my lord, and the Lordship, CD perhaps not received. May I pray for an interim protection? Because Lordship, the petition number 1 is the brother-in-law of the victim, Lordship.
Intimation must have already gone. They will get the CD soon.
Yes,
We
Lordship.
will
And
consider it.
moreover, Lordship, petition number 2 is a father-in-law, Lordship, 65 years old, Lordship, and not named in the FIR itself, Lordship.
You should have got the order on the very first day itself.
Because Lordship, on the first date, Lordship, perhaps due to some mistake, Lord.
It cannot be.
We could not able to.
Okay, so, okay, when can you bring the case?
Well, short date, my lord.
Where, from
From
which
Bongaigaon,
district
ma'am.
it has to come? Bongaigaon?
Bongaigaon.
Okay, heard Mr.
My
NH.
Lokhimpur, my lord, Bogino DPS.
Heard Mr.
NH.
NH Bormia, learned counsel for the petitioners. And Mr. K. Bosher, learned APP for the state. Mr. K. Bosher submits that a case diary has not been received and prays for another date. For placing the same, prayer is allowed. List this matter on 3rd.
Heard, my lord.
3rd of September 2026.
Hi, Lord.
Yes, Mr. Abdullah.
May it please, your Lordship, the previous bail application, my lord, FIR at page 8, my lord.
Case diary is there.
The CD not received, my lord. In this case, my lord, CS submitted. We get a communication, my lord.
So, CSI, you try it there.
Yes,
If you
my
fail,
lord.
come here.
Yes, my lord, Lordship may give some interim protection, my lord.
No, interim, you already are, is
No,
on
no,
it.
my lord, no,
Then I could have extended it, but no interim.
so, my lord, the Lordship may protect me for some days, my lord. Or Lordship may pass away, let me.
It's okay, you move it there. Then
Lordship,
come here.
Lordship.
Okay, heard Mr. S.M. Abdullah, learned counsel for the petitioner, and Mr. K. Bosher, learned APP for the state. Mr. Bosher submits that the case diary in connection with the present case has been submitted.
Right.
White charge sheet number?
I charge sheet number 217/2026, dated 7/8/2026.
217 of 26, dated 7.
Well,
8,
that may be kept as a
2026.
part of the record, man, that
Yes,
communication.
as such, the learned counsel for the petitioner submits that he be permitted to move the appropriate application before the concerned court. Prayer is allowed. The matter is closed.
Obliged, my lord.
The, what? That, no, not required.
No, nothing, my lord.
Okay.
Obliged, my lord. 41, my lord, here, my lord, a very petty offense, my lord, what happened, my lord? Manoj, allegedly a motorcycle has.
Case diary is there.
CD not received, my lord.
Lordship may kindly see page 7 is the FIR.
But then,
Lordship may kindly see, Manoj, there is, Manoj, the persons who were named in the FIR, they were arrested. They have stolen the motorcycle, and accused page 7, Manoj. Accused of Reki Budin and Tahid Ali, they were arrested, Manoj.
But then you did not get the.
Manoj,
We will fix a short date.
On that day, Manoj,
We will fix it.
when landed PP has prayed for a short date, Manoj, if Lordship reads the FIR, there is nothing against me. No, there is nothing against me. Against two persons, the motorcycle has been stolen. It has been recovered. It has been recovered, Manoj. Now, Manoj, the police is searching me for nothing, Manoj, because the alias motorcycle has already been recovered.
Okay, you have, right. Heard Mr. S.M. Abdullah, learned counsel for the petitioner, and Mr. K. Busho, learned APP for the state. By this application, the petitioner has prayed for a pre-arrest bail in connection with
In connection with what?
Hajo PS case number 367 of 2026, registered under section 305B of BNS 2023. Full stop. The copy of the FIR, in connection with which the petitioners are apprehending arrest.
One petitioner, Manoj.
A petitioner, the petitioner is apprehending arrest, was lodged on 5/8/2026 by the informant, namely Samnoor Ali, by which it was stated that on 4/5/2026, 4/5, the FIR is lodged very late.
Yes, Manoj.
4/5/2026 at around 2 a.m. Some unknown miscreants had stolen the bike of the informant from his courtyard. Full stop. The informant further stated that on being searches being made, the public interrogated the accused person who were named in the FIR, and that both of them confessed their participation in the said theft. So how are you? Why are you?
Manoj, actually, Manoj.
It was sold to you.
No, Manoj. It was not sold to me, Manoj. There is nothing against me. Only I knew them, Manoj. Only I knew them, but they have stolen it and they have done that. I am known.
Okay. Full stop. The learned counsel for the petitioner submits that the name of the petitioner does not find place in the said FIR, neither he was connected with the said offense. Mr. Connected with the said offense. What is this forwarding? Forwarding
is those two persons.
anything against you?
No, nothing, man. No.
Mr. K. Busho, however, submits that there are other persons who are involved in the offense of stealing. And as such, the police is searching the other accused persons. Full stop. In this case, the case diary has already been called.
My lord, police, my lord, make a
And
petition, my lord. They are
however,
not
in the
praying for a next date to, my lord, submit the same, my lord.
However, in the interim, the petitioner be released on, the petitioner be released on interim pre-arrest bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the in arresting authority under the following conditions. He will appear before the IO within a period of 7 days from today. He will not influence the witnesses. We will not so and so. The Mr. Busho submits that he would produce the case diary on
Next day, 17/9, my lord.
on 17/9/2026.
I'm deeply obliged.
List accordingly.
Obliged, man.
19. आज की रात्रि दिन बोल दी 19.
Yeah, please, Your Lordship. My lord, this matter is relating to rejection of my Jimma petition or Jimma of 18 numbers of cattle, Lordship. The present petitioner is
Cattles.
cattle.
Where is the rejection order?
My lord, rejection order is at page 45.
40?
45. The lordship may,
18 number of kettles.
yes. Is the petitioner is the lawful owner. My lord, you, is a long order, your lordship may take the page 49. 48, the last paragraph. The Honorable High Court in visit so and so and so and so made it clear that though the judgment passed in Dayan Foundation number so and so will not preclude a court from granting Zimma to a owner, but the condition stressed that FIR should not disclose a prima facie case of cruelty by the owner. Owner who are accused of cruelty or against whom a prima facie case of cruelty is made out cannot be allowed to assume custody of animal, as that would defeat the very object of PCA Act and subsequent rules made thereunder. In the present case, it is seen that the
Cruelty is there.
my lord,
So where is the FIR?
FIR lordship is at page 16,
Page
16.
16.
The vehicle was intercepted and drive.
So all the 18 kettles were on a same vehicle.
Same vehicle.
So that will lead to cruelty, no? At best, you can transport 6 vehicles in one, or 6 cows in one vehicle.
My lord, that will establish in the trial. My lord, we are paying only for Zimma of the cattle. Their lordship, under similar circumstances, lordship, this honorable court has was pleased to lordship release the.
Every criminal case is on the facts.
My lord, in the
Stolen cattle was
there is
proceeding
no
towards
bar under law,
Meghalaya.
lordship.
Promptly, Naka checking and so. Registration. So what about the truck? Was it given in custody?
Yes, subsequently track of.
On Torrens, where a number of cattle or various the animals were packed dangerously beyond safe custody, loaded in a extremely cruel manner and concealed under a black colored tarpaulin sheet. Also could not produce. Let a report come from the IO.
Oh, the charge sheet has already been submitted and learned trial court lordship has already taken cognizance.
The cows are in the Goshala now.
Goshala now. Since lordship 31/7/2000.
What are your documents showing that?
Documents lordship I have given lordship from lordship is 23 onwards. Each receipt lordship contains 2 numbers of cattle. 9 receipt is there lordship. Page 23, 25, 27, 29.
This was purchased on which date?
Purchased from lordship
29/7. And the FIR was on?
31.
What? 31?
31/7/2026.
31/7 and 29/7. Caesar made on 31/7.
29/7.
No, Caesar on 31/7.
Yes, 20, Caesar lordship is 18. On the same date.
How many invoices are there?
Lordship 9 invoice.
In respect of 18 cattle?
18 cattle.
How come?
Each lordship contains 2 numbers of vehicle, cattle. Page 23, your lordship will see.
Where it is?
In the bottom lordship,
Oh,
your lordship
horn.
will see.
Horn
Damora
2 numbers.
Duta.
What? Huh?
Damora Duta. In the next page 25 also.
Boron.
Damora.
Hing hai?
No.
Horn.
Damora Duta lordship, your lordship.
Damora Duta, where it is?
In the bottom lordship, Jontur Nam.
Page?
Page 23.
Yes, 23 only I'm holding.
Page 23.
Jontur Nam. Oh.
Yeah, Damora.
Damora Duta. Acha.
Page 25.
So everywhere it is Duta.
Everywhere is lordship.
Duta.
Two cattle. These documents are also placed before the lordship.
But during the Caesar, you could not place any documents. Maybe you have manufactured it later.
No, lordship, we have placed it. That is reflected.
But then that is not the FIR. It is said that you did not place.
No, that is in the FIR, but the order, in the impugn order itself, lordship, the same thing has been reflected. That he has produced produced the receipt, but the police said that that receipt is yet to be verified. That was the report of the police.
What to do, Mr. Busho? Admittedly, he brought it in a very cruel manner. But then, what is the purpose of keeping it in Goshala? Goshala also cows dies.
Yes.
A person looks after his own cows, but cows which are given by the government to be kept, not being taken very good care of. Okay, heard Mr. M. Khan, Learned Counsel for the petitioner, and Mr. K. Busho, Learned APP for the state. By this application, the petitioner has prayed for quashing of the order dated 17/8/2026, passed by the Additional Chief Judicial Magistrate, Kamrup, Amingaon, in PRC case number 1126 of 2026, arising out of Changsari PS case number 181 of 2026. Full stop. By the said order, the prayer for custody of 18 number of cattle by the petitioner was rejected. In the present case, oh no, the case of the petitioner is that number of cattle of various breeds were seized by the police in connection with Changsari PS case number 181 of 2026 on 31/7/2026. Full stop. It is stated in the FIR that on a credible information that a vehicle was carrying stolen cattle, suspected stolen cattle from Rongia to Meghalaya. The police conducted a Naka checking and intercepted the vehicle, and upon checking the said vehicle, found 18 numbers of cattle being packed on the same. It is for full stop. It is also alleged that the said cattle were loaded in the truck in a very cruel manner, and that documents were asked from the driver of the said vehicle, but no documents could be produced by them. Mr. Khan, Learned Counsel for the petitioner, submits that all the cattle were purchased by the petitioner from the market.
Lordship, Bakbor.
Petitioner.
Market. Borbata.
There are
Bakbor Market, Borbata.
from Bagbor market, and the receipts were also enclosed with the petition. He submits that the petitioner is the rightful owner of the said cows and be given the custody during the trial of the said case. Full stop. Mr. K. Busho, Learned APP for the state, however, submits that the cows were the cows were loaded on the truck and was transported in a very cruel manner. And the owner of the cows are responsible for the same. And as such, he prays that no custody should be given to the owner. That is the petitioner. Full stop. I have heard the counsels and I've gone through the records. In the order rejecting the custody to the petitioner dated 17/8/2026, it is stated that the cattle are kept in the Goshala. It is stated, right?
Yes, Lordship. Shurubi Goshala.
What Goshala?
Surobi Gosala.
Kept in a Goshala. And it was further directed by the said order that the authorities of the Goshala should submit a monthly report about well-being of the said cattle. Full stop. However, the owner of the cattle, that is the petitioner, had given the documents showing the purchase of the said animals by giving the consideration to the seller. Full stop. It is a settled position of law that articles seized in connection with a criminal case should be given in custody to the owner or the person from whom it is seized or to the insurance company under which it is insured. Full stop. In the instant case, the items seized were cows, and the petitioner has shown his ownership over the same. With regard to cruelty being committed, the same be seen during the trial. As far as the custody of the cattle are concerned, the same may be given to the owner, that is the petitioner. However, before giving the custody to the owner, the investigating officer should.
Lordship, trial court lordship.
Hmm?
Now it will be trial court lordship. Additional CGM, Kamruk.
But who will give the custody? What will not give?
Court order will, lordship, will necessary.
The concerned authority
Lordship.
will give the, however, it is directed that the concerned authority, before giving the cows in custody to the petitioner, should follow the necessary procedures such as taking photographs, taking bond, as well as the guarantee that the petitioner should produce the cattle as and when required during the trial. The police, the concerned authority is also directed to follow other conditions as required under the law. Petition is disposed of. And no more, it is 5 o'clock, all pending taken out. Any other bail matter? What are the other motion matters here?
Item 18, my lord.
18,
Item 22, my lord.
22,
Only notice, my lord.
22.
POXO is there, my lord, only notice, my lord.
It's not 22 to the extent.
If possible, my lord.
Item 21, please fix on Friday.
Okay, 21 you write on the prayer made by the learned counsel for the petitioner. List this matter on Friday, that is on 28.
Item 43, Lordship may kindly give one date.
43.
It is
Acha, all, he'll give you the dates. Okay?
suspension of.
Only on that
22,
22
my
to some.
Section 6 of the POSCO is there, my lord, notice. That is the prayer, my
That you have challenged what?
lord. FIR, my lord.
Third, Mr. A.S. Tapadar, learned counsel for the petitioner. And Mr. K. Bosho, learned APP for the state. By this application, the petitioner has challenged. The petitioner has prayed for quashing of the first information report along with all consequential proceedings arising therefrom. Full stop. The FIR reveals the offense committed under the POXO Act, and as required under the law, a notice to the informant should go. As such, issue notice petitioner to take step for service of notice upon respondent number 3 through the office of the registry, routed through the office of the public prosecutor. Case study not required, we will see. Okay. List this matter after 2 weeks on a date to be fixed by the registry.
CD is required.
For quashing of FIR we will see. Every case why CD.
You know, my lord, the statement will come, my lord. The big,
Let the notice be served.
I'm deeply obliged, ma'am.
Other matters he will give me.
A fixed date, ma'am.
Oh, list this matter on Kibara Dear.
I'm-
16th of September.
I'm deeply obliged, ma'am. I'm deeply obliged.